Assalamu alaikum, good morning, and welcome to today's national stakeholder consultation titled Whistleblowers Vital to Break the Chain of Corruption is Their Protection, organized by the Center to Combat Corruption and Cronyism, C4 Center, with the cooperation of the National Center for Governance, Integrity and Anti-Corruption, GIACC. I'm Arif Hamizan from C4 Center, and I'll be your MC for today. So firstly, we're delighted to see that we have attendees from such a wide range of fields and backgrounds joining us today, from MNCs to the civil service to the general public, and we look forward to an enriching and engaging event with all of you. As a quick recap, we have two exciting sessions today with some pretty esteemed panelists. Session one will be led by Ms. Cynthia Gabriel, Executive Director of C4 Center, where we will have a keynote from Tan Sri Abu Qasim Muhammad, Director General of the GIACC, a presentation on the context and plan of the federal government from Dr. Punita Silivaraju, Director of Social Policy, the Legal Affairs Division, Prime Minister's Department, Malaysia, and a presentation on the experiences and reality of whistleblowing by Deputy Commissioner Dato' Izani Wan Ishak, Senior Deputy Director of the Investigation Division, MACC. These presentations will then be followed by a Q&A session moderated by Ms. Cynthia, which we can all partake in as well. After our virtual coffee break at 10:30, our second session commences with a panel on recommendations and best practices with Mr. Christopher Leong, President of Law Asia, Mr. John Chung, Compliance Counsel at Intel Asia Region, and Mr. R. Nadiswaran, Senior Investigative Journalist. And this panel will be moderated by C4 Center's Mr. Sudagaran Stanley of C4 Center. And this will also be followed by a Q&A session, which we can join in as well. Now, before we begin, do allow me to cover a few housekeeping topics. To our attendees, if you have any questions for our panelists during the Q&A session, you can type them up in the Q&A box, which should appear at the bottom of your screen. There should be a button which says Q&A. And alongside your question, it would be great if you could also include your name and the organization that you're from, along with the panelist or the panelists that your question is directed to. Other than that, today's event is also being streamed live on Facebook, and the recording of this event will remain there for you to revisit and to share amongst your colleagues in the future. So I think with that, we can begin. So, the Whistleblowers Protection Act came into force in 2010, but over the past decade, it has been the subject of sustained criticism from many sectors, particularly in the way it is deemed inadequate in encouraging whistleblowers to come forward. In fact, it can even be considered more detrimental to whistleblowers, as there are restrictions on the kind of information these whistleblowers are allowed to disclose and to whom they can disclose that information to. So, recognizing that fighting corruption must remain a priority of the government, it is imperative for Malaysia to create an enabling landscape for whistleblowers to report wrongdoing and to commit to making law enforcement institutions free from executive influence. So, with that being said, what could be done moving forward? And I think that's what we're all here to find out. So with that, allow me to introduce Ms. Cynthia Gabriel to lead our first session.
Thank you very much, Arif, for that kind introduction and taking us through the program. I am very delighted to actually be the moderator for today, mainly because this has been a very, very critical part of the work of Malaysian anti-corruption groups. And we are very, very grateful and appreciative that the GIACC, the Governance, Integrity, Anti-Corruption Center, had actually joined hands with us to put together a very, very important, what I would say, morning. Although it's the day of the budget and we thought that we would not be able to get much responses, we're actually very, very happy to see that we've got more than 140 people registered for this event, and it's also out on Facebook Live. So without further ado, I just wanted to put a little bit of a context here on What I would say is a 10-year review, perhaps, on the Whistleblower Protection Act, which came into force in 2010. And a little bit of data from the MACC, which appears kind of old. And I hope Dato' Izani, who is also on the panel, will be able to share more updated details, is that in 2012, out of the 8,953 complaints that were received by MACC, only 28 were from whistleblowers. And during that same time, 2011 to 2013, only 39 whistleblowers were actually given protection. Now, this is a very telling sign that the number of whistleblowers who come forward with legitimate or not so legitimate, but complaints that require further investigation are at an extremely low level. And we'd like to find out why, actually, and how that environment can be further improved. And if there's some real challenges we need to meet, whether it's legislative or more than that, which is creating an enabling environment, an environment which will actually allow whistleblowers to feel empowered that they can come forward. So without further ado, I'd like to invite an old friend and someone who's been at the forefront of trying to push for policy reform. He was the former MACC Chief Commissioner when I got into this whole thing of setting up the Center to Combat Corruption and Cronyism. We've worked together on several things, through good times, bad times, went through many difficult issues of trying to bring forth justice around corruption scandals. Tan Sri Abu Qasim is the man, and he is now the Director General of the GIACC. So we'd like to hear from him the current situation of whistleblowers in the country, how policies are being improved, hopefully, not set back, and where we are with a lot of economic uncertainty, political turmoil before us, etc. So over to you, Tan Sri.
Thank you very much, Cynthia. And first of all, I would like to thank C4 for organizing this conference, and it's very crucial and very important for me because the participants and also your participation in this issue will help the government, especially my center, to really recommend with the cooperation with BHEUU. I think you are very right. It's very, very timely for us to really relook at the Whistleblower Act. But allow me to really share with you the purpose and based on my experience on whistleblower, especially on Anti-Corruption Commission. Before 2010, the Malaysian anti-corruption law basically have a kind of section in the Anti-Corruption Act that protect the, previously we call it as informant, but some of our informants are whistleblower. And I can share with you, if you can remember, that how we investigate big syndicate on lesen terbang. I think the driving license issue, and I got it. I managed to get the case, and we managed to get those involved because of we have few whistleblower. At that time, there is no whistleblower law specifically as what as we have now, but we have a law on in Anti-Corruption Act that the anti-corruption officers have the right to refuse to give the details of the informant. At the time, we call it as informant. Some of the informants are basically, they are really whistleblower, but they don't want to be known and they don't want to be exposed in terms of their identity. That's why at that particular time, I myself manage them, and indeed there's some kind of reward that we give to them and protection. I remember that we protect our whistleblower to the extent that so that nobody knows that they are our whistleblower. We also arrested him, as the whole group that we arrested, including him, so that nobody knows that he was the whistleblower. Here, the issue of either you are informants or whistleblower, it depends on how you define it. But for me, whoever who are in the organization wanted to reveal the illegal act there is on a disciplinary issue or in the criminal offense are those who can be classified as the whistleblower. For this purpose, I believe that the Anti-Corruption Act, basically they have a basic fundamental element in handling whistleblower. But the issue that we are facing now is on, there are a few issues that have been highlighted when the Whistleblower Act was introduced. First, as a practitioner, I would like to see on the both sides. I know one as a former anti-corruption officers, and also I was the chief integrity officers working in the private sector. My understanding of this Whistleblower Act, if you make a disclosure to third party, there is a possibility that you cannot be, you are not being protected under the Whistleblower Act. We have to really relook at this element because the Malaysian government and we also, the government also encouraging a lot of private sector to have adequate procedure under Section 17A on the corporate liability. And one of the initiatives that they should make to have a whistleblower policy. There must be a kind that an initiative taken by the organization that they are looking into, they're doing something to create a whistleblower policy in such a way like they appoint a whistleblower officer or integrity officer who handle all the complaints and so on. So what will happen if a person make a complaint to the whistleblower policy or the chief integrity officers, then after a few months, they found that there's no action against his complaint. Then he go to the authorities. He go to MACC. In this situation, is he going to be protected under the Whistleblower Act? Because he went to other parties. In the Whistleblower Act, you've been protected if you go to the law enforcement, the authority. So we have to look at this. How can we or the law cater the situation where the definition of the authority, maybe I'm just giving a scenario so that we can think in a bigger perspective, that how can we rope in those authority in the company as also the authority. This is something that I like you to venture, but it's not that I'm saying that we are looking to that. As a practitioner, I was a chief integrity officer. For those chief integrity officers in the company or in any organization, if they are law enforcement officers, like what a lot of anti-corruption officers have been seconded to into the organization, the companies, GLCs and all that. It's okay for them. If they are also the recipient of complaint, they manage the whistleblower internally, I would say that is still okay because they are the authorities. But if the chief integrity officers are not from the law enforcement agencies and no action taken, then the complainant went to see the law enforcement agencies. And because the law has been drafted in such a way that if you make a kind of contact and give the information to the third parties before you come to the law enforcement agencies, you may not be accepted or can be protected under the Whistleblower Act. Please look into the matter. The purpose of witness protection, so Whistleblower Act, way back we have to look at the United Nations Convention Against Corruption, because these are one of the elements that have been promoted by UNODC and through UNCAC, United Nations Convention Against Corruption, as a very important tools to break the chain. At the end of the day, if you study many anti-corruption agencies, many initiatives on fighting corruption fail because public fear of reporting. Public do not have confidence with the organization or institution that they wanted to make reports. The reason why they don't have confidence because of the retaliation against them. They believe that if they take action and they make report and all that, who's going to protect them? This is something that is the United Nations Convention Against Corruption believe that by having Whistleblower Act, it should help the public to have confidence and they're willing to come and make reports or complain. So we have to go back to the basic principle and reason why the Whistleblower Act has been introduced, is to create confidence and to make to protect those who complain from any retaliation action against them. So the law should be relooked in the area that how to strengthen this area. And on top of that, again, in many agencies and organizations in the government agencies today, based on the National Anti-Corruption Plan and also the decision made by the government, all government agencies are required to have their own organizational anti-corruption plan. And one of the elements in most of the organization anti-corruption plan is that they must have a whistleblower policy. It is a must. One of the areas that the risk area that they have to identify are on how easy and confident staff of any department or organization easily willing to make complaints to the chief integrity officers or in the organization. And these issues, again, boils back to the framework, legal framework that we have now. In many government agencies, MACC has given or appointed the MACC officers as the chief integrity officers. In these particular issues or situation, I think that we have no problem. Again, for those organizations do not have anti-corruption officers or law enforcement officer in the general, then they may have a problem with the whistleblowing policies or initiative. So again, I just wanted to concentrate on certain issues and to leave it to you all to discuss, and hopefully before end of December, I would like to either we meet physically or we have a small group discussion, especially with C4 and BHEUU. And the law enforcement, especially the practitioner, the Anti-Corruption Commission, and those who really try to implement this law, to have a discussion and come up with a proposal as soon as possible, so that we can bring the matter to the government. And I believe, I strongly believe that we don't have so much a problem of reviewing and amending this Whistleblower Act. So for that purpose, I would like to end my presentation, my keynote. Again, I would like to thank C4 for organizing this discussion group or convention or this ceremony. I hope that at the end of this session, we will come out with a lot of dissecting all the real issue and come up with a real proposal that tangibly can be proposed to the government, and it has impact on the policies and amendment of the law. So Cynthia, thank you very, very much. And for those who really wanted to participate in this discussion, I hope that it will give a lot of contribution to our work in improving and in reforming the initiative on fighting corruption in this country. Thank you very much.
Thank you, Tan Sri. Thank you for that open and very detailed sharing. I understand that you can't stay for the overall Q&A, but because you also completed your overview in less than the time given to you, may I just start by asking you several questions just to prompt the discussion a bit. It is often described, there's many words that come with describing whistleblowers. They are usually looked at as traitors or heroes, or they're dissidents, or they're even patriots. So it really depends on how the people in power actually have that will to dissect a particular investigation. I kind of got on myself personally onto the wrong side of whistleblowing, thinking that the complaint that I tried to expose would be investigated. But actually what happened was the authorities had come after the whistleblower instead of the investigating the complaint itself. So in that sense, the fear is real. And I was reading up about what was happening to Julian Assange, our great WikiLeaks guy. He's an example of how far it can go in trying to actually become either a publicity seeker or a campaigner for the truth. But here is where I think what you explained just now about being an informant or whistleblower, or whether there's other intentions to, defame and so on and so forth. So according to the UNCAC, this is a very important component of fighting corruption. If we do not have proper whistleblower protection, then everything else sort of just nullifies itself. I just wanted you to describe a little bit about where you think, apart from Section 6, about going out to other people who are not law enforcement, the Whistleblower Protection Act is also subservient to, say, the Official Secrets Act. So which means if you expose a classified document or information, then is there really issues of strong liability and something that we can put forward to the government to balance that whole issue of security, confidentiality of info and all that? Most of the time, informants get leaks from inside, and that's how you know. I mean, even in 1MDB, many of the issues actually came from internal sources as well. So may we have your views on this?
Yeah, Cynthia, thank you for that question. I think one of the discussion that you have to make afterward is on how far can the whistleblower blow the whistle to the public? And that while the law said that you have to give the information and complaints to the law enforcement, the issue here, can a person get the protection after blowing it and informing the public? This is a matter of philosophies, it's a matter of it's a matter of policies. Please study with all others whistleblower policies in other countries. Is allowable, or they should be covered? A lot of countries have defined differently. Some people, when they make a report, they inform the law enforcement authority, and they expected that the law enforcement authority to investigate. And but sometimes, due to whatever reason, maybe the investigation is slow, or the outcome of the investigation not to his expectation. Then the person with good intention or whatever intention that in his mind, he went to the media. So that the justice, she get or he get the justice. With this situation, how can we go about? Is the law can protect this scenario, or the law cannot protect? I'm just giving you an example, that an area that we have to discuss. Again, like in the private sector, if the chief integrity officers refuse to investigate for whatever reason, the staff of the company came to law enforcement agencies. Under my interpretation, my understanding of the law, that there is a disclosure to the third party, and the law enforcement agency may not give protection because you have disclosed to other parties. But this is a contradiction between the policy of the company which you want us to have 17A, you wanted for us to have a whistleblower policy. So we have a whistleblower policy, we have a whistleblower officers, but unfortunately the whistleblower policy may not be effective. Then the staff or the complainant in the company go to MACC and make complaint, and because he has given the information to a third party, then there is a possibility he cannot be protected. So the law has to be relooked, that how to cater, how to solve this problem. These are as a practitioner, former practitioner, sorry, I would say that we have to really look at this issue. And there are other things also which I will discuss with you when after your discussion and with BHEUU and with all the practitioners.
Yeah. Thank you very much, Tan Sri. There is time for just one more comment from anyone who is online, but I don't see any Q&A or any issues. What about the panelists themselves? Do they want to say anything before Tan Sri signs off, because he has to go off for another meeting now? But really, it has been a very good introduction to set the tone of where we are. Both from the law enforcement side, from the practitioner side, and very importantly from the policymakers side and the government side. So thank you very much, Tan Sri.
Thank you.
We really welcome your comments. Thank you for joining us this.
Thank you. I'm looking forward to see you again and to have further discussion before 4th of December. Thank you.
Unfortunately, we seem to be having some slight technical difficulties on Cynthia's side, Miss Cynthia's side. So with that, perhaps I'll take over for this session and introduce our next speaker, presenting on the context and plan of the federal government, Dr. Punita Silivaraju, Director for Research and Policy, the Legal Affairs Division, Prime Minister's Department of Malaysia. Welcome.
Hello, can you hear me?
Yeah, hi Cynthia.
Yeah, okay, that's great.
Yep.
Okay, the internet just went bust for a while. Now, I just wanted to introduce Dr. Punita as our next speaker. She has been someone who has worked with C4 very openly, in a very engaging manner, despite some challenges here and there. Dr. Punita is the Director for Policy and Research at the Legal Affairs Division of the Prime Minister's Department, what we often call as BHEUU, is the Bahagian Hal Ehwal Undang-Undang. And she's responsible for many things, really. Her CV is like so impressive, I'm not sure which ones to read. But just briefly, she has been leading many law reform areas, including the review of the Malaysia Agreement, 1963, the Special Committee on the Review of the Mandatory Death Penalty, as well as the head for development of the COVID-19 bill of Malaysia. So she's really out there at the forefront. And I got to know Dr. Punita when she was a real greenie. And what is a real greenie? When she was with the Energy, Green Technology and Water Ministry and developed a lot of issues on low carbon, green growth legislation, etc. So it's a very, very rich experience coming from the civil service. And we're very appreciative that you've taken time off today to also let us know real time, currently what BHEUU is actually doing in terms of trying to get the Whistleblower Protection Act organized and sorted out so that it could be tabled for amendments in Parliament. Over to you, please.
Thank you very much, Cynthia, for that lengthy introduction. I think Tan Sri has left. Yang Bahagia Dato' Tuan-Tuan dan Puan-Puan. Good morning. Sincere appreciation to Cynthia and her team for inviting us, for giving us the opportunity to share a little bit about the Whistleblowers Protection Act that we have, and also, of course, to share with you what we have in the pipeline in the months to come, maybe you know, some of the issues that Tantri had highlighted earlier. Probably I'll also be talking a little bit about that. So I've got a slide. If I could just share it with you. Give me a sec. Okay. Yeah. Boleh. Okay. Okay, I need help with this. Okay. Okay. Right. Yeah. Okay, it's just all right. So basically, I think what given to me is on the context in terms of the way forward that we have for this act. Okay. So I'll be just touching briefly on the introduction and then some salient features of the Act itself, certain provisions in the Act, some of the issues that we've identified after engagement, some of the engagement we've done with stakeholders. And of course, I'll also share a little bit about the steps that we've taken and also what we have in the pipeline. Okay, I think Tan Sri covered a little bit about this, where the start of this act. It was when Malaysia signed the United Nations Convention Against Corruption in 2008, and this convention specifically looked into two important articles, Article 33 and Article 37 of the UNCAC. And I'll be going into that article in a while. And following that, there was a need to have a domestic law. Okay, so this is basically the articles that we are looking at. One is protection of reporting person. So basically to have a domestic legal system, and of course to have a mechanism of reporting or a mechanism of disclosure in which disclosure can be made, and also competent authorities. Of course, Article 37 then looks at the cooperation between enforcement agencies, the existing enforcement agencies, how they could share information in terms of disclosure and also detrimental actions that may be taken. Okay. Now, following this, there was, I think, this was actually brought up in the National Key Results Area discussion that looked into fighting corruption and crime. And following that, there was a study, and then the Act was passed in 2010. Okay. So the purpose of the Act basically is to, the ultimate aim initially was, of course, to combat corruption and to encourage any form of misconduct by encouraging and facilitating whistleblowers to disclose improper conduct, okay, both in the public and private sector. And of course, number two is to protect persons from any form of detrimental action that others may take, and also to have a mechanism, a system in which this can be managed. So the content of the Act consists of 27 sections and seven parts here. What I will do is I will just touch on, I'm not going to touch on the entire Act, of course. I'm just going to look at the salient features of whistleblower protection itself. Okay. So what protection provided under this Act, Act 711? Okay, basically, if we look at section 6, it talks about improper conduct. So the interpretation, of course, of improper conduct is any conduct which is proved constitutes a disciplinary offense or a criminal offense into section 6. And of course, when can one disclose this improper conduct? One can disclosure is made when one reasonably believes that any person has engaged, is engaging, or is preparing to engage in an improper conduct. So even if you know that someone is planning to do so, you can disclose it. Okay. Now, of course, with improper conduct comes the area of the risk. Once some form of improper conduct has been disclosed, there is a risk of detriment. So there is a link between the disclosure of improper conduct and the possibility of any form of detrimental action being taken. This is where the enforcement agencies are required. Okay, so if we go back to what protection is provided again, I just mentioned improper conduct under Section 6. And of course, Section 7 looks at the protection itself. Where does this protection come from? Basically, we have protection under confidential information, which is Section 8. So basically, confidential information talks about the information, the whistleblower, the identity of the whistleblower, who this whistleblower is, his address, his information, everything about him. That needs to be protected. The person whom the disclosure is made against, that person's identity also needs to be protected. The information itself, what is it he is disclosing, that needs to be protected. And if the whistleblower believes that there's going to be any form of detrimental action that may arise from his disclosure, that information needs to be protected as well. That is what the confidential part, the protection on confidential information relates to. Now, Section 9 is about immunity to civil and criminal actions. And Section 10 talks about detrimental action, protection on detrimental action. What is interesting here is it actually also is extended to anyone that is associated with the whistleblower, not just the whistleblower, but someone who's associated with the whistleblower. And Section 11 is the revocation of whistleblower protection. And what is interesting here under Section 11 is if the whistleblower is part of the improper conduct he disclosed, then his protection may be revoked as well. So this is another interesting element. Of course, there are many reasons to revoke one's protection, but this is something that has been most spoken about, and I will share that with you later in terms of our engagement with the stakeholders. And finally, of course, this disclosure then, who is it made to? It is made to the enforcement agencies listed in the Act. Basically, if you look at enforcement agencies, under Section 2, the enforcement agencies are basically ministries, departments, agencies, or statutory bodies established either by the federal government, state government, authorized investigate, who have the authority basically to investigate, and also enforcement, basically the enforcement agencies. So the two important prerequisites here are they need to be authorized under a written law, or established under a written law rather, and have the power to investigate. Okay. Now, current scenario is we have 7 enforcement agencies. Now, this is not in the Act. As I mentioned, these enforcement agencies are not listed, but this is very administrative. We have PDRM, we have MACC, we have the RTD, Customs, Immigration, Companies Commission, and Securities Commission. So, if they are, I will not be able to really go into it, but what I will actually show you some statistics after this, and we can actually discuss how active these enforcement agencies have been in terms of complaints. Okay, now if I could just go into the issues identified. Okay. Now, as I mentioned earlier, we had some engagement with the a wide range of people. I think there's more engagement required, and of course that is because there has been a decline in the statistics of the cases report, but there have been reporting under this Act. Unfortunately, protection is very limited. Limited number of protection is given for many reasons, which we can go into it shortly. And this is the statistics: complaints received and protection. And you will also, I don't know, maybe MACC may correct me if I'm wrong, but most of the disclosure, most of the protection is under MACC, if I'm not mistaken. And very few from other enforcement agencies. Okay. Now, if you look at issues, my slide is clear. Okay, in terms of issues, the engagement that we have done with stakeholders, basically with NGOs, CSOs, even GLCs, of course, with the enforcement agencies themselves. So these are some of the issues that were brought to us. And of course, I'd like to take this opportunity to hear from all of you out there. What do you think about these issues? Or do you think that, more issues that you would think you would like to raise to us? We'd be very happy to take this on. Okay, in terms of first one, okay, the need to relook the number of enforcement agencies. That's because what we have right now is just 7 enforcement agencies, and the powers under Section 3, 2 enforcement agencies. Basically, as I mentioned, it goes way to it goes to the government agencies, state level agencies, even local councils. But what we have right now is just the 7 enforcement agencies only. So there could be a need to actually increase this number to more enforcement agencies. I don't know, that is a question to look at. And also, when we speak to enforcement agencies, the issue that they may raise, is basically they say that when you want to disclose a particular improper conduct about someone, you can go to any of these 7 agencies. So if the improper conduct is about issue under one agency, but if you go to another agency, then they may have the difficulty of understanding what issue and how to administer, even how to investigate this particular improper conduct that person has brought forward. That is one. The other thing is they've also mentioned that a lot of times administrators who are sitting there, the integrity officers who are stationed in a particular enforcement agency just to handle whistleblower disclosure, they tend to move. So, one year you have person A, and then the next year you have person B. So what happens to the improper conduct, the information which has been disclosed already to one person? Can that person disclose it to another person? Because if you look at Section 6, it says you're not supposed to, and if you do, it may be revoked. So that's another issue. Of course, the third issue, then they say that they're already bogged down with existing work. All enforcement agencies, they're busy, they have the existing work to do, and over that, this is something extra for them to look at. So this can also, these are some of the issues that they have brought forward to us. So there is a need to look at that. Now, secondly, is the need for the recipient of disclosure to be extended to include internal reporting. I think this was mentioned by Tan Sri earlier as well. Internal reporting at organizations, particularly on disciplinary cases, not so much on criminal cases. For example, can we open this up to the private sector as well? That's a question. Can they do internal reporting, their own human resource, for example, to settle disciplinary cases before even it's brought to enforcement agencies? Because right now, if a GLC or let's say a private sector has an issue, and if there's internal reporting, and they can still bring it to the enforcement agency. So can this be settled at their level? Especially cases, relating to disciplinary cases, can it be settled through internal reporting? So that's another question, perhaps for everyone to answer and maybe respond back to us. Okay, in terms of clarity of improper conduct, where we can focus on 2 areas. One is the area of public interest. There could be certain disclosure of improper conduct which is big, which is of huge public interest. So those kind of improper conduct should be given, probably a different mechanism to look at that. and a different mechanism to look at issues of disciplinary action, for example, in organizations, because they are very they're varied in magnitude. Okay, next is the proposal to establish a single or a central agency in charge of implementation of whistleblower protection. So this is another area that which we were looking at as well, because right now the focus is limited, because the enforcement agency doesn't only receive disclosure of improper conduct, but they also have to investigate. So that makes it a little difficult for them, because they also receive it and they also investigate. So the focus is divided. So if there could be more focus, a more focused approach in dividing the administration of protection and the investigation part. So that will be something that we could look at as well. Okay, I think there was an issue that Cynthia brought up in terms of the OSA, but I'm not going to go into the OSA. Basically, talking about conflicting provisions in the law itself, because Section 6 here, there is a proviso that says provisos that look at disclosure of improper conduct itself in the Section 6. But under the Penal Code, Section 203A, 1 and 2, there are also some conflict in that area, because on one hand, it allows you to disclose improper conduct to under the whistleblower protection. You're not supposed to disclose. On the other hand, on Section 6, you are allowed to disclose to the other party, but in Section 203, you're not supposed to. So there is a bit of a conflicting provision in the law itself. Also, implementation issues. If you look at Section 8.2 of confidential information, shall not be disclosed to anyone. But if this issue is brought, or if this particular case is brought to court, then what happens? Will it be disclosed? So there is an issue of implementation issue as well. I would say also conflicting. Now, the issue of application of revocation to a whistleblower participating in conduct. If you look at Section 11, there are many reasons why revocation can take place. Of course, one really important area which was brought up to us was if the whistleblower himself has participated in the improper conduct, then how? What happens to him? Is it fair for his protection to be revoked? Probably he is actually doing us a favor. Should we revoke his protection for actually revealing something to us? So that's another question. So there were suggestions that there should not be revocation for this kind of situation. Okay, and the next is Section 26, which of course a lot of them brought up the area of reward. Okay, so we were looking at a scale for reward, because it mentions reward, but it doesn't really give us a scale. So we don't know what type of reward, or where do we actually reward one when they disclose improper conduct. So these are some of the issues that we've identified. Now, steps taken and way forward very quickly. Okay, well, basically the government is in the midst of reviewing the Whistleblower Protection Act. So it is something, it is timely. We definitely think it's time to review the act. So a committee has been set up at BHEUU's level with the enforcement agencies. We've had several meetings with enforcement agencies and also some GLCs looking at what actually happens on the ground. But of course, BHEUU would not be able to really relate to what happens on the ground. I think the enforcement agencies will be the best people to explain or relate the experiences with everybody. Now, a workshop was conducted with experts from UNODC, and they helped us actually look at certain areas in the law that actually has there's a loophole there, and also certain gray areas that we need, and inconsistencies that we need to look at. And we had then focus group discussions with GLCs, NGOs, academicians, and these are basically what I shared with you earlier were quite these were regular repeating issues that have been repeated by most of them. And of course, we are planning to have focus group discussion with more enforcement agencies at the state level, at the local councils. So we are looking, as I mentioned, we are looking at getting more information from other enforcement agencies, people who have not actually used this law, but they have the powers to actually do it, to see whether there is a possibility for it to be extended to these people. And also, of course, the private sector organization, the internal reporting that we spoke about earlier, that I spoke about earlier. And also, this is actually an important area for us because BHEUU is actually reporting to the Special Cabinet Committee on Anti-Corruption, Dogma, chaired by the Prime Minister, on whistleblower protection. So it's not something that we just say, because we have to report, and there is, so we have to actually take actions, which would definitely benefit the rakyat as a whole. So I think that's all. Let's see. Yep. So that's all from me. Not a very long presentation, but thank you so much for listening.
Thank you very much, Dr. Punita. That was really very insightful, really. Just when we thought things were at a standstill, you presented quite a lot of details in terms of how work at the ministry level, as well as some committees have actually been ongoing despite the very difficult year that we've had in 2020, both in terms of COVID, economy, and political uncertainty. But I see there's some pretty interesting comments in the Q&A box, which is also available to you. But I'd like to start with this question from Ben Lucas, who's asking you to provide a little bit more detail on the complaints received. But interestingly also, could you explain the huge drop in complaints in 2020? And is that linked to COVID? So perhaps tackle that question first, because Dato' Izani has, someone called Izani Ismail has also asked another interesting question. But could you start with this whole question of the drop and more detail on the complaints received?
Yeah, sure. In terms of statistics, I would say that, as I mentioned, the law is there. Yes, it has been there since 2010. We only have 7 enforcement agencies. Okay, and these 7 enforcement agencies can receive disclosure from anyone. If I'm not wrong, maybe MACC can correct me if there's any form of improper conduct. So when you go and you disclose to someone, and there is a possibility, of course, according to the law, also mentioned by Tan Sri earlier, if you receive a particular improper conduct, a disclosure, you are not supposed to say to anyone. And if it's just mentioned even to another person, immediately your protection may be revoked, which is something that is be contested, of course, something that is it's hard for one enforcement officer who is sitting in the enforcement agency to just handle it himself. What if he's leaving? He would have to definitely pass it down to somebody else. So these kind of issues actually lead to a lot of trust deficit, I would say. There is an issue of trust deficit. There is an issue of confidence. So when you actually go and you disclose, you don't know how far will you be protected. And what if one thing is protection for yourself, then protection for your family, and then you talk about detrimental action, because once you have disclosed, there are, of course, there is high risk of action being taken. So any form of action, even if it's the smallest, as much as whatever happens in your organization, in a private organization for that matter, it affects you. So I would say that the drop has not been not only in 2020, there has been a steady drop over the years. If you look at the I would not be able to go in detail. The statistics I shared with you are basically what is in the open data. If you want more details, you would have to go through the enforcement agencies because they have the details. Seriously, I'm not Cynthia. Really, they have details. It wouldn't come to us. They only have numbers basically, because BHEUU's role is actually to administer the law and amend the law. So the enforcement agencies will have the details. But the decrease has not been only 2020, and I wouldn't say it accounts to COVID alone, but it has been a steady decrease over the years. And I think my reason, what I mentioned earlier, that the confidence, the trust deficit, the mechanism itself to to go into any form of disclosure itself is needs to be relooked, I would say.
Okay.
Dr. Punita, if I may add and ask you your comments. I think there's trust deficiency syndrome that the 7 agencies are suffering from. The case of the SSM is a clear example. The 2 officers blew the whistle. Minister sent the letter to the minister and the prime minister, and the minister issued a letter penalizing and reprimanding them. At the end of the day, that guy lost his pension too. Now, if you can't afford protection to this kind of people, right? How do you expect people to come forward and with all these complaints? I'll come to another issue later, but that one, this is the first step now. I think a few of us, most of us have faith in the MACC and the way they operate, but we do not, after the experience, the SSM, I don't think I would dare go and talk to the DG of Immigration, talk about his officers who are in cahoots. I would not have the confidence to do it. So that's what I'm saying. Unless you restore the confidence of the people in the system, the whistleblowers are not going to come up. What say you?
Yeah, thank you very much, Nades, because I think that would be a very important way forward and recommendation to look at quite seriously about the trust deficit issue and how to actually create a more enabling environment. Now, unfortunately, that is not really the task purely with your division and your department. It is really a lot to do with political will and the climate that is out there. So I'd like to thank you very much, Nades, for that. Dr. Punita, I believe there will be more time for you to answer that question, also because we will need to hear from the MECC, which is the primary law enforcement agency, in the challenges to actually look at the UNCAC convention as an international convention and how it gets operationalized really at the ground level. And it is extremely challenging because, as I said just now, there's so many terminologies linked to blowing the whistle on purported graft and the confidence that Nadiswaran talked about that is needed. Or there's many terms, negative terms that are referred to as well. Are you a traitor? Do you have other political intentions, so on and so forth, defamatory issues and all that. But just before we move on to the next speaker, I'd like to ask if some of these committees, focus group discussions and all that are also open for public review, that it's just good that we have you on board today, but if there's a way public can actually intercept, give feedback, like what journalists like Nadiswaran is talking about, how do you actually fortify the thing, and how open is it? Is there something on the website that people can access? Would you be able to make a slight comment on that?
Sure, Cynthia. Of course, before the amendments of any law, whether it is whistleblower or otherwise, at least for now, BHEUU is looking at engagement. So for now, I would say our engagement has been with the enforcement agencies because we want to know what are their problems, because they are actually facing these issues. We have engaged academicians as well with their views. We have engaged NGOs and CSOs. I think C4 also attended one of our session. We've engaged the GLCs. Okay, once we put everything together, we will try to come up with something that we could share, maybe a survey, a questionnaire, just to get more views about what people think about the whistleblower protection, and even for you to comment on how definitely this will happen. We will do it because we wouldn't want to come up with a law that is doesn't satisfy everyone. So definitely proper engagement will be done. So it's yes to answer your question.
Okay. Okay, thank you very much. Thank you so much for that. I'm sure there's many more questions. So please get it out on the Q&A section, because at the end, after the speaker from MACC, we'll have another round of dialogue. So stay tuned, Dr. Punita, don't sign off yet. Okay, now our next speaker is really from where all the conversation is heading towards, which is the Malaysian Anti-Corruption Commission. Now we have with us Senior Deputy Director of the Investigation Division, Dato' Izani bin Wan Ishak. He's been at the Anti-Corruption Commission for some time now. He's a certified fraud examiner since 2015. And he's been there for some time, actually looking at many issues and many laws that have come into place, and especially on looking at the effectiveness of Whistleblower Protection Act and where the challenges are from the law enforcement agency themselves. So without further delay, I'd like to welcome Dato' Izani bin Wan Ishak. Over to you. Dato', are you there?
I think, Dato', you have to unmute. Unmute your microphone.
Shifa, can you help with that? Dato'?
Hi, Cynthia. Hi.
Hello.
Hello, can you hear me?
Yes, very well.
Yeah. Okay, thank you for inviting me to join this session. All right. Together with me today is my learned DPP, Mama Api, and officer from Whistleblower Protection Unit in BHEUU. Okay. First, I would like to begin on my experience on Wbpa. Okay. First of all, I was a party of a panel in drafting on Wbpa in 2010, which is the law that we now enforce in MACC. All right. So I'm also the head of panel of constructing the MACC SOP. Okay. And I've been taught in Vienna and Timor-Leste on best practice of on our best practice in MACC on whistleblower, all right? And I also taking charge of the cases, including the Wbpa cases. Now, the context of my talk is on, the first one is the realities in enforcing Wbpa in MACC, the challenges faced by MACC, and I'll produce some statistics. And the last one is the case study on Retaliatory Action and success story. Now, the references on this session is on.
Can you click on your file? We can't see it.
Sorry?
Can you click on your file? Now we can see your computer screen.
Yeah. Okay. some technical problem, I think. Can you see my attachment, my file? Hello?
Yes, now it's good.
Okay, thank you. Now, the references for this talk is on the first one is on the law itself. Okay, the second one is on Attorney General's Directive Number 1/2011 on this matter. The guidelines which is from BHEUU, and then the SOP of our SOP, MAC SOP on whistleblower. Now, our SOPs, we have to comply with the laws and the relevant laws, right? We have taken account with all the challenges that we foresee. What are the challenges that we might have in on enforcing this law? You know, we work as the SOPs that was signed by our Chief Commissioner on the which is Tan Sri Abu Qasim. Right now, the most important component in enforcing this law is the registration of whistleblower. Right now, this is the most important because why? Because we have to protect the identity of the whistleblower. Right now, the info or the information on improper conduct became on by various channels, including officers of MACC. Okay, now we have to give the confidence to the public how we want to protect the identity of the whistleblower. That is the most important things, because if the public gain the confidence on how we protect the identity of the whistleblower, then they will come to us. Okay, that is so in MACC. How it goes is like this. There's once the whistleblower give the information on improper conduct, okay, the officer that received the information is the one who know the identity of the whistleblower. Then they will submit the information and to the whistleblower protection unit. So in this case, there's only two persons who knows the identity of the whistleblower. In fact, if myself or my superior officers didn't know who is the whistleblower, because that one is untuk kita melindungi pemberi maklumat, the identity of whistleblower. That is the most important thing, the secrecy of the whistleblower. Now, the other thing is, how did we build up the confidence of the public to appear to come to us? Because we know that once your identity have been concealed, no one's know, then we can provide the protection for you. Protection of identity is the most important element. Now, okay, the second one is in MACC, the management of investigation of improper conduct. The management of the investigation of improper conduct only comes when there's a lodge a report of legitimation by the whistleblower. All right. So the special unit in MACC, which is whistleblower protection unit, is the one who will conduct the investigation. All right. So the identity of the whistleblower will always under protection, concealed. No one's know. The identity will be contained. That's the most important. That is the most important. How we gain confidence. So as I go on, I'll show you the statistics, how it goes, that the level of confidence has been increased. Now, to comply with the provision of Section 6, all right, on the whistleblower that the information on improper conduct must be lodged to the enforcement agencies. All right, now, what MACC done is that we have attached the CIOs to GIACCs, industry and department and private sector. Now, because we know that the MACC officers attached to these agencies have the power under MACC Act. All right, they have the powers under Whistleblower Protection Act. That is the most important thing, that the public must lodge the improper conduct to the enforcement agencies. So this is how it goes. Because they know when they receive the improper conduct laporan, okay, report, they channel it to the Whistleblower Protection Unit in our HQ. So we got a few cases, to show that most of the cases that we have in the JLCs, in the Ministries Department, come from the our CIOs that in the GLC. Okay. Now, the other thing is we also train the CIO for the local and international participant at Macc to comply with the law and rules and regulation. So that's why how we work now. Now, it's a common challenge. We have foreseen all the challenges. Why? And then it was quoted by the late Datuk Wbpa. These is all the challenges that we are facing in enforcing the law, Wbpa law. So we at MACC take the challenge, all right, and we foresee how to overcome the challenge. So how, and then now the most challenge that we are facing, that public was not given enough information on Wbpa. Our hands are tied. We only investigate, we only receive information on cases which is under our jurisdiction. Now everyone comes to MACC to lodge cases which is not our jurisdiction. So for this matter, the NGOs could convey this message to the public to say that only cases on corruption which is under our jurisdiction, then they come to us and we can protect them. That's the message, all right? Now, the other thing is the request on protection on such as monitoring the home, residence, office security, and monitoring the movement, that we are facing, that they didn't have the information, the real things, that we cannot protect them from the day one they lodge the on the information that they lodge to us, right? These things, this request only when there's protection, it happens when this determinate action was taken against them. It's only happened when the determinate action was taken against them. All right. The other problem is this media social reporting. We are facing the problem that once the issue or the issue of any offences under our jurisdiction pop up in the media, all the suspect of the accused will conceal or destroy the evidence. That's why we need for the whistleblower to come to us. All right, we in investigation we need of element of surprise to procure the evidence. Right. Now, this is on the statistic, the latest statistic that we have registered about 329 whistleblower since 2011. The whistleblower they registered is increased by years. Right now, out of 329 whistleblower that we have registered, we only we have comfort that on 297 whistleblower, right? 32 was not entitled because of certain criteria which is under the law. We have opened about 210 of 211 investigation on the info that was lodged by the whistleblower. All right, then we have to refer about 14 cases to other law enforcement agencies. Now, from the statistic, it shows that the level of trust, the level of confidence to MBC has increased. All right. It is all right. So on the red line to show that this is the linear comfort linear. You see, the level has been increased. Public has come to MACC to lodge on the info on corruption and other corruption and matters that is under our jurisdiction. Now, this is the cases on retaliatory action. We have the data from 2014 until now. Now, there's a report for retaliatory actions was lodged by 32 whistleblower. 32 whistleblower. This is about 10 and then only 9.8% compared to 9.8% compared to the whistleblower that we have conferred the protection. This is very small number. All right. Now we have opened about 32 IPs. Why these cases before this? Why these cases can proceed? Because of the first one is because the whistleblower revealed their own identity. One. The other one is there are certain cases that whistleblower withdraw the retaliation report. All right, now there's a few cases that we have tried before. Okay, we have tried before, and then we'll try to the moment that the whistleblower has been taken retaliatory action, we go to the agencies that take the DI against them. See that the moment if you proceed with the DI, and then we will lodge the case in the court. All right. At the time, the whistleblower, the agencies withdraw the DI against the whistleblower. Okay. Now, this is the cases of disciplinary action, as I showed before this. Now, there's only one case, the only case in Malaysia, in criminal, the only case since this law has been enforced, that we managed to bring one criminal case against the accused to the court. So, because this case is dalam perbicaraan, I cannot reveal, but we hope bila bicara berjalan, apa yang penting ialah kita hendak test the law. We have to test the law what is the whistleblower, apa protection, apa sebenarnya whistleblower. So let the court decide apa interpretation in the court itself. So this is the case yang inilah. So that's what I can share. And then my learned friend will share on a few cases. Gabriel, Cynthia, share lagi. File mana dia? Apa boleh cakap dulu nanti dia so kita boleh mana share slide ni besar tak boleh kan. Okay. Okay, as explained by Datuk Izani just now, this is the first case that we charged in court for the infringed under section paragraph B, subsection 10(3) of the Whistleblower Protection Act. So I unable to share the fact of this case, but it is a good message. I believe this is a good message to the public that the MCC actually take a serious action to protect their whistleblower. Okay, then since we have a very good case and for us, this is clear that there is an offense conducted by the accused of this case. Then the case was charged to the court. Okay, but I would like to share with the speakers and also the participants about the one civil case regarding on the criminal actions taken against the chairman of Institute Professional Baitumal Sendirian Berhad. I believe maybe some of you had the knowledge about this case. It is about Sheikh Omar Said Agil against Institute Professional Baitumal Sendirian Berhad. This is a case where the Syed Omar, the plaintiff, as a CEO of the Institute Professional Baitumal, reported to the MCC and also to the PDRM regarding to certain improper conduct of the employment of the Institute Professional Baitumal. And then in consequence of the disclosure, the IPB or Institute Professional Baitumal took various disciplinary measures, action and detrimental to the plaintiff, i.e. to the CEO of the IPB. To cut short this case, during the trial at the court, there was evidence showing that the Institute Professional Baitumal took the action against the CEO after the CEO lodged after the MACC and the PDRM came into their premise to start the investigation. Then the court said that it is clear that based on the fact of the case, the action taken by the IPB to the CEO due to the reason that the CEO disclosed the improper conduct that happened in the IPB. So if you want to, you can search the case at Syed Omar Said Agil against Institute Professional Baitumal Sendirian Berhad
2018 6 CLJ 397. There's the facts that how the case happened. I would like also to share, just to share my personal knowledge about the Whistleblower Protection Act. First, I believe we need to give the message to the public that how is the Whistleblower Protection Act is can be used to protect their interests. Okay, we have to explain to them about what kind of the offense or report or improper conduct that they can report to the agencies, to the relevant agencies. And the most important thing for me, from my view, is what are the agencies that they should report the improper conduct. Because as we can see in a case, Rokiah Muhammad Noor and Menteri Perdagangan Dalam Negeri, Koperasi dan Penggunaan Malaysia, there is a case until the Court of Appeal, I believe. It is where, regarding the SSM, the court, one of the findings of the court is that the parties who lodged the report, the Deputy Chief Executive Officer and Director of the Training Academy, both persons were not entitled as a whistleblower because their report not to the agencies as mentioned under Section 2 of the Whistleblower Protection Act. So that's why the court, when the court made the finding that they were not protected under the Whistleblower Protection Act, then the case against them was not the report that they lodged, and then the action taken by the agencies against them will succeed. So from my view, one of the most important things that we need to educate the public that you should know, they should lodge the report through the proper channel. And then in order to enhance the effectiveness of the Whistleblower Protection Act as well, we need to look also on this kind of issues, because maybe as we discussed earlier, the other participant discussed earlier, we need to expand. Maybe we need to expand the agencies to give a lot of agencies that the public can lodge their improper conduct. That's all.
Dato', is there any final words before you end your presentation?
I need pressure from the NGOs, from the public to come to MACC to launch a report on improper conduct. That's all. Support from you all. Thank you.
Thank you very much. Okay, we've had a really very interesting morning listening to first Tan Sri Abu Kasim from GIACC, and then Dr. Punita from BHEUU. Dr. Punita had shared several considerations for us to speak about now and also to bring forward into the next session. And Dato' Izani, I think from the MACC perspective, there seem to be a couple of questions already posed in the Q&A chat, because you might want to look at it. So let us take the question from Roslan Hanapia, who is actually talking about the statistics that you shared, and that whistleblowers who came forward to lodge reports have seemingly deteriorated in the last 2 or 3 years, 2018 to 2020. And are these signs that public confidence has deteriorated because of the fear of retaliation? And what would be your comments on this?
Betul. Ya. I check with my statistic first. 2018, 2000.
Can you?
Okay, 2018. Based on my record, there's an increase compared to the previous year, 2017. 2017 we have 15 registered whistleblower, and it increased to 59 to 2018. 2019 increased to 64. I didn't see any decrease. It's increase, but in 2020 so far we have 45 whistleblower protected because of this. I think because of the current situation we are having in COVID-19. So based on
just no, your statistics, the number of complaints received and IPs open is going down. The yellow line on your graph. Yeah, it's going down. That means you cannot say your complaints are going up. Action is coming down. Could you explain why so little action against? Can you put that graph of yours on?
Okay, hold on, Dato. There are a couple of requests for you to reshare the statistics, the slides just now on the number of whistleblowing reports, so we can look at those while you're speaking to us.
Okay. Sure. Okay, now this is the
This is the graph. Yeah.
All right. We see the registered, the investigation on the yellow lines shows what investigation paper open.
Yeah. Yeah.
All right. The number of whistleblower that we convert and registered and we convert increase. I'll show you this one. All right. You see this one is look. All right, now you see registered whistleblower from 2016 has been increased from 42 to 50, 59, 64, and now it's only 45 because of I mean the current situation, or it is until September. I think the statistics is until September. So this is the registered whistleblower that the whistleblower come to us to lodge the on DI.
You have only investigated 25. What about the rest?
Investigated. No, investigated. Numbers of IP is 200 and.
No, I'm looking at 2020 registered whistleblower 45, convert 39, investigate only 25.
I mean the issue kadang-kadang yang tidak ada kaitan dengan kita. Isu yang remeh.
No, that means 20 out of 45, 25 are investigated. I mean 20 got no case lah.
No.
Might be others issue reported.
Others issue reported.
In the IPs.
Okay, might be 45 that whistleblower registered whistleblower.
Yep.
They come with the, I mean, they come satu maklumat tu ada 3 whistleblower. Maklumat yang sama. Tapi bila kita siasat just one IP. Satu maklumat, satu laporan kelakuan tidak wajar, dia datang dengan 2-3 orang, kita convert 2-3 whistleblower protection. That's why IP kita tengok on cases yang ada kaitan di bawah kita punya jurisdiction. Itu saja yang itu yang kita siasat. Any question?
Thank you. My next question is, Dato and DPP, why did Syed Omar have to file a civil suit instead of you affording him the protection?
I'm sorry, I beg your pardon, sir.
Why did Syed Omar have to go and file a civil suit against Institute Baitumal? Shouldn't the MACC have accorded him the protection under the Whistleblowers Act?
Okay. I believe from the case, you can see he filed the civil suit against the Institute Professional Batu Mal because the institute not intent, but already took action, disciplination, and then try to terminate, to suspend his position at the Institute Professional Batu Mal. And then in this case, he report about the improper conduct to the MACC at that time, and also to the PDRM. Okay. In this situation, the issue that the court should determine is whether the Syed Omar Syed Agil protected as a whistleblower. Because at the time, I believe it is not stated in the case, in the decided case law, but it is, I believe that the court needs to determine whether he is a whistleblower or not, because he maybe at the time he's not registered under to be a whistleblower under MACC. You know, maybe he not
the court proceedings clearly states that he went to both the MACC and PDRM.
Yes.
Both of them
Yes,
should have
correct.
registered him as a whistleblower. Why was this not done? Look at this now. How do you expect public to come forward to tell you, right, when these kind of things happen? Now, if I come and whistleblow, I go to pay my own lawyers to get protection instead of you providing the protection. What kind of confidence are you instilling in the public by doing this kind of thing?
Actually, that's a very important point. But may I suggest that perhaps this is also taken up in Chris Leong's session, unless MACC wants to respond to this, because it is a very important point about why do the public need to file civil suits when they should be trusting the criminal justice system and the law enforcement to protect them. I mean, unless you want to make a comment, I'd like to actually get another question on the table as well. Dato, would you like to respond to that?
I think he was not registered dia tak registered sebagai whistleblower di MACC. Dia cuma bagi information on practice on salah laku di jabatan dia. Now the process is that you have to come forward to MACC, all right? We have the form. You have to fill up the form. Okay? And then we register you as whistleblower in our record. Then whatever action taken against him after that, then we will cover under Section 9. He was not registered.
Even if you're not, this is what I'm saying. The public have to come and register and then seek protection. Shouldn't this be automatic when I come to you with information, right? Shouldn't it be automatic for you to provide protection? Now, please let me finish. Dato and DVP. You're asking your NGO, you asking NGOs and public to come and promote this thing. But what kind of confidence do you give the public when you do these kind of things called the register, isi borang? What is this? Yeah. I come with information, you take it down automatically. I should be a whistleblower.
It's not automatic, sir.
Well, there are several. I think we'll need to move from here because there are several very serious issues about public trust and public confidence, which we will also discuss further. But something that is very important, I think, for law enforcement to realize that these are many issues that deter public from coming forward. So we can see actually in the statistics that you share that the numbers are really, really extremely low. And if only we enable more whistleblowers to come forward, we may be able to sort out a lot more graft problems in the country, let alone the ones that involve political office of very high people. I'd like to actually get on to that next question of reward, because one is public trust deficit. The other is if the whistleblower has actually played a tremendous role in coming forward with information. what is the reward system that is actually given to whistleblowers? As I said, they could be seen as patriots. They could be seen as people who are extremely useful and important to the country's growth and integrity, in building culture of integrity. So is there any reward system? I mean, there's something in the Whistleblower Protection Act, but is there an example that you would like to share?
Berkaitan dengan reward, memang ada provision under the law, under section 26. But as it is now, we don't have any mechanism documented to pay the reward, because the enforcement agency may order such reward. So we don't have, I think kita tidak lagi berbincang, tak pernah berbincang dengan BHEUU, dengan agensi yang enforce this law. What is the mechanism untuk kita membayar reward? Tetapi sekiranya ada permintaan, kita akan buat perbincangan. So memang kita belum ada mekanisme lagi untuk bayar reward. Sebab melibatkan peruntukan dan juga
Okay, so itu bermakna dari segi MACC, the publicity untuk datang ke depan untuk membuat aduan to actually promote the use of Whistleblower Protection Act is not really strengthened yet. So because people need to feel that feel safe is one thing, but feel like they're doing something that can actually help the country, and so they will not be any retaliation or any kind of reprisals against them. Tak ada apa-apa yang buruk lah yang akan berlaku kepada mereka. So is there a promotion of this kind of reward system for whistleblowing from MACC side?
So far memang tidak ada satu lagi mekanisme on the reward.
Okay. Thank you.
We need to discuss with BHEUU yang berkaitan dengan reward.
Yeah, I think that could just add. Basic talks about reward. It's very vague. It just says you may reward one who discloses improper conduct at criminal actions. So what we can do is we can discuss further on issues of the quantum, for example, even a scale, a reward scale. I think that is something we need to discuss further with the enforcement agencies. I think we can take this up. It's one of our one of the issues that were brought up to us here, so we can up.
Okay, Dr. Punita, since you're online, there is another question for you. It's about private sector and adhering to Whistleblower Protection Act because they don't fall under the enforcement agencies that have been described. So what would be the most suitable term to include in existing whistleblower protection policy to reflect that the company is complying to the Wbpa?
Yeah, I was just going to answer that question. Basically, I think the current situation, you can set up your internal reporting, but maybe Dato' Izani can correct me if I'm wrong. But if you want to bring it further, if you want to seek protection under the law, you would still have to bring it up to the enforcement agencies. That's how it is now, right now. So you may have your internal reporting, you may bring it, but the moment you bring it up to another party, assuming to the enforcement agency, you may lose your protection. So it kind of defeats the purpose, because your protection has to be from, you will only receive protection if that particular person reports it to the enforcement agency. If I stand corrected, Dato' Izani. So if it travels multiple sources, then you would lose your protection. So I would suggest that you probably would have to look at us making some changes to our law before this can come in full force.
If I may add, private sector, syarikat-syarikat besar yang ada di Malaysia sekarang ni, they have their own integrity unit. Alright, they don't have the power, but if they collect ada laporan berkaitan dengan salah laku di bawah Whistleblower Protection Act, dia ambil maklumat tu. Okay? And then they lodge the report to MACC. So he was protected. Integrity unit was protected. Because why? And sebab dia lapor kepada agensi penguatkuasa, integrity unit tu. Dalam law, dalam undang-undang berkaitan dengan whistleblower ni, protection bukan sahaja diberikan kepada orang yang mendedahkan kelakuan tidak wajar kepada ni, juga dipanjangkan kepada mana-mana orang yang pemberi maklumat itu hendak dilindungi. So this is benda yang kita it's very simple. Integrity unit di private sector kan dapat maklumat daripada dia punya pekerja dia. Alright, now dia lodge kepada MACC. Datang kepada MACC, I lodge kelakuan tidak wajar. Okay, saya perlu protection di si borang. Dalam borang itu sendiri pun ada dia siapa lagi dia nak lindungi. Dia akan sebut dia nak lindungi orang yang beri maklumat pada dia. ABC. Why? Because maklumat ni dapat pada dia. That's mekanisme yang kita boleh cadangkan. Itu saja. Wujudkan satu unit integriti di syarikat-syarikat swasta. Dan memang ada syarikat swasta yang besar sekarang ni ada unit integrity. So that is how kita memang kita menghadapi masalah, challenges. Right now, macam mana kita nak mengatasi masalah itu, bagaimana kita nak accommodate, memberi kemudahan kepada pemberi maklumat. So undang-undang is still undang-undang, tetapi macam mana kita nak mengatasi masalah itu dengan cara kita. That's the problem ni. Boleh dapat apa saya ni? That come to us dan kita akan explain how we protect. Itu dia. As an enforcement office body, macam mana kita boleh protect?
Faham Datuk, tapi if I may pick up another point tadi, sama dengan Nadiswaran tanya tadi, the burden is actually felt by the public because they have something that could actually impact upon themselves. So one is it could happen in the private sector context. Another is it could happen because of experience in a government department ke apa. Ada satu contoh pun case of teacher absentee in Sabah and all this, and dia pergi lodge complaint semua. But the issue here is about the burden is felt by the public. One is on the issue of should we go to MACC? Will MACC protect us? Will MACC listen to our complaint? Adakah apa-apa yang akan berlaku? And why should the public feel that they have such a big burden on their shoulders that they cannot actually trust the law enforcement? So kadang-kadang they go to their member of parliament. Itu pun salah dari segi undang-undang. So
they also come to the press.
The issue here is about confidence and about trust. So I'd like to turn the thing around to ask MACC, how can the public feel a bit more confident and trust? So whatever Dr. Punita is doing on the policy side will actually have a bit more impact and weight. Because right now, the numbers of complaints are really at a very low level. It does reflect public confidence in law enforcement. So is there anything MACC would like to create an environment? Come report to us, because this is something that you can do. And if it's a case that we can solve, you could be rewarded. Something like that. Is there a comment from you on this aspect?
Mekanisme yang ada di MACC is very simple. Kita kata come to MACC. In fact, sebenarnya di MACC is we go to you. Kan? We go to you. Memang kita kata datang ke kita, tapi sebenarnya you ada information, just call us at any time, at any place. Apa yang pegawai MACC buat di cawangan whistleblower ni, ialah dia akan pergi kepada berjumpa dengan whistleblower itu sendiri yang nak bagi maklumat. Arrangement itu yang kita how kita conduct kes-kes yang berkaitan dengan whistleblower ni, we go to them. Because kalau datang ke sini satu masalah, kita tengok mungkin dia punya identity reveal. So we go to them. Okay, the problem is bila report pada the third party yang tidak ada kuasa-kuasa untuk menyiasat. Okay, so who want to comfort the protection? Satu, because do you have the mechanism to protect? Okay, adakah you punya identity tu memang dijaga oleh third party tu? Yang penting, the most important thing is kita nak jaga you punya identity saja. Identity you supaya orang tak tahu. Cuma dua pihak saja yang tahu. And then kalau dari segi protection dengan ancaman, kalau ramai orang tahu, kan? So how we are going to protect you? Itu mekanisme yang kita ada di SPRM ialah walaupun kita come to us, tapi sebenarnya we go to you. Because there are certain peraturan yang kita kena patuhi, certain borang yang perlu kita isi for the purpose of record. Okay? For the purpose of record, kita nak keep the record of whistleblower. Bukan semua tahu. Di MACC cuma 2 saja yang tahu. Yang menerima maklumat itu dan yang menjaga bahagian itu. Just 2% saja yang tahu. In fact, saya pun tak tahu dan orang atas pun tak tahu. Itu pendapat saya. Yang berkaitan dengan reward ni, we have to discuss dengan BHEUU. Itu sajalah.
Okay, terima kasih. Ada satu lagi soalan. There's a few comments daripada this person called Adriana Abu. If you look at the chat, there's a question on GLCs. Ada kebanyakannya have MACC representatives attached to them. This has been a practice for many years. So the rate response and action in GLCs should be good lah, markedly improved. Technical cooperation separate from government. Tapi kita tengok dari segi charges that have been placed in the last couple of years on many of these important GLCs, for example, FELDA, many other GLCs that have suddenly come to the fore because of issue rasuah. Can you explain the effectiveness of the role of MACC representatives in all of these government departments, including dalam isu procurement, dalam isu perolehan, where MACC representatives sit in all these departments? Are there incidents of whistleblowing that is actually made to MACC representatives? Is there an impact of having officials there?
No. It's very simple. We need the information from the whistleblower. Alright? We need the information to assist us. Dia ada benda-benda yang berkaitan dengan documentation semua tu, kita tak perlu pada whistleblower pun. Kita gunakan kuasa-kuasa kita yang ada untuk mendapatkan dokumen tersebut. That's why kata datang kepada kita. Lodge kepada kita, just bagi tahu what is the case about ini, and then on investigation, let us kita buat. Dan kita tak perlu kan you datang untuk bawa dokumen. Kalau ada bagus. Alright. Tapi kalau you bagi tahu kata berkaitan dengan procurement semua sekali ni, so just give us what is the project. Yang lain biar kita jalankan siasatan. Kita nak dapatkan maklumat itu saja. Maklumat berkaitan dengan salah laku yang dilakukan di mana, siapa yang buat salah laku itu, berkaitan dengan sebab apa salah laku di rasuah ataupun salah laku itu berlaku. Right? Itu saja. That's why kata dia bukan datang dengan maklumat yang betul-betul lengkap, no. Okey, maklumat yang berkaitan dengan itu saja, dan biar MACC atau agensi berkuasa yang membuat tugas. Setakat ini tidak ada rekod lagi, kita tidak ada rekod lagi mengatakan bahawasanya ada pemberi maklumat diambil tindakan di bawah mana-mana undang-undang, tak ada lagi. Di bawah undang-undang, tidak ada whistleblower yang dituduh di bawah sebagai di bawah USA tadi, tak ada lagi. There's no record to show that. Dan memang kita betul-betul protect. Itu saja.
Okay, terima kasih. Okay, then I think, is there any comments for Dr. Punita, because she's ready and eager to pick up some questions as well. Dr. Punita, if I can trigger off some of the things that you said. These focus group discussions that you have had so far with law enforcement, NGOs, and all that. There was a question previously about reporting to the JKMR, which is chaired by the Prime Minister. Is that itself a process that we should feel confident about? Because wouldn't it be a lot better if the reports went directly to Parliament as a better check and balance, and for policymakers to directly hear from you where the law should be improved, etc. Because given the current situation before us, is reporting to the Prime Minister something that you feel enough for accountability and for public confidence to be developed?
I think
okay, if you can turn on your camera, it'll be good so we can see you.
Sorry. Okay. I think what we're doing right now is report the Dogma committee. Basically, the committee looks into the proposed amendments. We are actually telling them that we are planning to amend the law itself. So they've given us some time to look at it. That's where the engagement is done. So we wouldn't want to bring it to Parliament as yet until the law has been drafted and and it's brought for debate in Parliament. Nevertheless, we do have a lot of Parliament questions on Wbpa. So that has always been answered. So, when you ask questions in Parliament, and a minister will answer the question accordingly. So, it is still brought to Parliament in that sense.
And on that note, is the NACP still there and part of the government's commitment to? The NACP is the National Anti-Corruption Plan, where whistleblower protection is part of what Tan Sri Abu Qasim said should be in every organizational anti-corruption plan. Is the NACP still relevant in this new government? Are they following the different pillars, etc.? Would you be aware of that?
I wouldn't be able to answer that question, Cynthia, sorry, because it's under country's jurisdiction. We in government, we are definitely taking action on the NACP because we're supposed to have organizational NACP for every government agencies. So we are doing it, yes. So if we are doing it, I assume that it is still going on as planned.
Okay, thank you very much. Now, Dato' Izzani, it looks like you are the one that everyone seems to be having many questions targeted at you, but there's one very interesting one about once investigations are complete, how does that information get translated back to the whistleblower, or does it ever get made known to the whistleblower? That's an interesting question there about once you have completed investigations. Dato', are you with us?
Yeah. There's technical problem. Now, di bawah whistleblower, memang kita we have to report secara berkala kepada whistleblower. What is the outcome and the progress and outcome of the investigation? It was stated in the law, and then dalam kita punya SOP pun ada. That it's the right of the whistleblower to know what the progress and the outcome of investigation. Hello?
So which means that once the investigation is complete, you would then, the next step is to submit your documents to the Attorney General's chambers, right? But is there a channeling back of the information to the whistleblower that the complaint has been solved? This is what we found out. What is the process of information dissemination? Kalau ada.
Yeah, sorry. All right. In the law itself, under Section 3 and our SOPs, that Section 13 is clearly stated that we have to report the progress and the outcome of the investigation.
To whom?
It was to the whistleblower.
To the whistleblower, okay.
Yeah, it's stated clearly under Section 13.
Okay.
Section 13. They
Okay.
have the right under the law.
Okay. So the whistleblower is informed at the end of the whole thing.
Yes.
That's what you're saying. Okay. So on that note, because time is also running out for the first panel, we take a little bit of encouragement that there is hope in a very complicated tunnel, that we could have more confidence building measures that are required to actually promote whistleblower protection and whistleblower reporting, because we would know at the end what actually happened to the complaint, and that the details of it would be given to us. I mean, there are many cases where the impact is very personal because you're reporting on someone who may have committed a malpractice that directly affects your quality of life or something like that, especially at local government level and things like that. So it appears that we're not lost at the end of the first session. There is hope in the current legislative framework, but we know that there are many loopholes as well that needs to be fixed. We are encouraged really to hear from MACC and BHEUU that efforts are still underway to study the amendments. We only encourage that public feedback and public insights are taken more seriously, and that there are more channels available for mechanisms as such. And most importantly, also for private sector, because we have the corporate liability provision that has come into force. And now there's a lot of interest and a lot of, a bit of panic also about what do we do to create a good, sound compliance system, which has very good whistleblower protection at the heart of everything, which we will hear in the next session. So I think this has been a very rich morning. We want to thank Tan Sri Abu Qasim, Dr. Punita, and Dato' Izani and his team for being very engaging with us, despite some challenging questions and all that. I think you've done a really fine job. Thank you very much. I'm going to hand it over back to the MC to tell us what to do. Definitely not to sign out, but to sign in after a short break. Thank you.
Yes, thank you, Ms. Cynthia. Thanks once again to Tan Sri Abu Qasim, Dr. Punita, Dato' Izani for your presentations and that very engaging question and answer session. So with that, I'd like to end our first session. Right now, we'll be taking a 15-minute virtual coffee break before our next session begins, which will start at 10:45. So thank you all again. We will see you very shortly.
So yang ni kena tengok lah. Jangan keluar dah. Cakap putih terapu pagi ni, kita lewat malam, terapu pun. Balik pun 1 lebih malam.
காஃபி பிரேக் விட்டாங்க, மூட் பண்ணிட்டாங்களா? மூட் பண்ணிட்டாங்களா?
Mari di sini. Ni tim dia ni. Cakap apa sih? Stop video. Dia stop video je. Ini rehat. Rehat dia.
Hello.
Boleh cakap Melayu. Saja nak cakap Melayu.
I'm trying to figure out now how to. Yeah.
Hi to all our attendees who are still here for the event. Welcome back. We hope you managed to grab a quick bite or coffee during the break. But without any further delay, we will now continue to our second session, which is a panel session led by Mr. Sudagaran Stanley. So over to you, Stanley.
Thank you, Arif. Good morning to all our respectable panelists, our presenters, and all our participants who are following us right now on Zoom and also on our Facebook page live. As you already know, as we're talking and deliberating this topic, we have representatives from the Legal Affairs Division whom are actually also following our discussion and taking notes to be deliberated later at the ministry level. On our side, whatever that we're discussing right now, we will also be coming up with a final report which will be presented to the government via our co-host today, the National Center for Governance and Integrity and Anti-Corruption, GIACC. Now, in the earlier part, we have heard from the government present their findings, interestingly, on the Whistleblower Protection Act. And right now, we'll go into the second part, where we have panelist speakers to give their inputs and suggestion on the Act. Now, we have chosen the panelists for this session from people who have real experiences on the ground and who have done extensive research on the field. You would note that we have someone from the law background, Mr. Christopher Leong. Also a seasoned journalist, Mr. Nadeswaran, and someone from the private sector, Mr. John Chung. This combination is so that we could try to cover every aspects and loopholes that needs attention and amendments in the Act. I hope the discussion would be interesting, intense, and lively, just as how the morning session was. And to all participants, if you have a question, may I remind you to type in your questions into the question box, which will be later addressed by the panelists. And if you also want, you could state your organization that you are from, so that we know the context of the question and so on. We have about 90 participants who are following us right now in the Zoom meeting. Now, without wasting any time, I would like to introduce our first speaker for the panel today, Mr. Nadeswaran. I'll start with him. Nadeswaran is, some of you already know him, award-winning veteran journalist, investigative journalist with over 50 years of experience, and has written extensively on corruption and good governance. Now, over the years, he has exposed and written on corruption issues within the administration. He had also served as a member of the MACC advisory panel until he was removed by the then Najib government at the height of the 1MDB scandal. Now, on his retirement from the Sun, he has, where he has worked for 17 years, he now writes regularly for Malaysia Kini and also involved in the training of investigative journalists. So now I pass it over to you, Mr. Nades, for you to take the floor.
Thank you. I think most journalists who do investigative stuff will always acknowledge the role whistleblowers are playing or have been playing. By right, they should actually go to the enforcement agency. But often they turn to the media for various reasons. A simple one I would like to illustrate is this story which I wrote way back in 2008. I couldn't find the original, but this says it all. The whistleblower in this case went to the MECC, right? And he was told that this is an administrative issue. It does not involve corruption. It does not involve any exchange of remuneration. Now, this minister broke all the records, appointed all the cronies in various places. The details are there on screen for you to see. And there's nothing anyone could do. So the whistleblower came to see me with this and thought I will be the guy who's going to be his savior, right? Unfortunately, I couldn't do much in the sense that except publishing the story and everything else. So at the end of it all, a minister who breaches all the rules, right? Overstaffed, creating jobs for cronies, gets away with it. Okay? So this is a typical example of why whistleblowers don't want to deal with government agencies. This is only one example. I can illustrate. I got plenty of others, including the Port Klang Free Zone. Right? The Port Klang Free Zone, police reports were lodged. Nothing happened. Reports were lodged with, at that time, the ACA. Right? Nothing happened until they came to the media and we broke the story on how a project that started with a budget of 2 billion ended up with the government having to pay 12.6 billion. Now, if this had not been highlighted in the media, the whistleblower actually came to see me. Rather, we went to see him in the middle of the night in some godforsaken place under the coconut trees in a restaurant. But the point to note is this: whistleblowers expect immediate results, or rather, not immediate. They expect results within a reasonable time. They don't get that. They don't see the results. They're going to find another place. For example, for example, if they come to the sun and I don't expose the thing in within 2 or 3 weeks, he'll be running to another journalist who will bring to do it. Okay, so for me, the most important thing is I on this act which had gone through for several times is that this requirement that a whistleblower must be registered. I don't understand how it's going to work. If I walk into a police station today, let's say I walk into the Petaling Jaya police station and tell them I want to blow a whistle on some activities. The sergeant on the desk does not know the Whistleblowers Act. Does not know the existence of any borang to be filled in. All I want to do is provide information. At first step, I fail. My argument is the amount any amendment is to be done to the Act. Anyone who provides information shall automatically be considered a whistleblower unless he himself leaks it openly. If you have noticed in the recent months, people going in front of the MACC building and saying, I've lost a police report, this is my report, and everything else. Once you do that, you lose whatever protection. But for the MACC, if you go and make a public announcement and the perpetrator reads or sees what you have done, his next immediate job will go and destroy all the evidence and go and harass all the witnesses. So in that sense, no protection should be accorded. But if people quietly come and give their report saying this is happening, they should be treated as an informant under the Whistleblowers Act, and there's no need for registration or whatever it is. I'll stop there for the moment to give the other members a panel to speak.
Thank you. That was quick and fast. Okay, fairly said. We'll come back to you on the questions later. For those who have questions for Ms. Nades, please type it in the question box, and we will answer that shortly. I would like to now go to Mr. Christopher, who is a lawyer and who has extensive experience in the fields of corporate and commercial litigation, shareholders dispute, banking litigation, and insolvency. Now, Mr. Christopher is also practices in the area of constitutional and administrative law. He was the former Bar Council chairman and the former president of the Law Association of for Asia and the Pacific. Presently, Christopher is the member of the AIAC Advisory Council, a member of the Taylor's University Law School Legal Profession Advisory Panel, a member of the Advisory Board of Monash University degree for Bachelor of Politics, Philosophy and Economics, a recipient of the 2018 Lifetime Achievement Award from the University of Nottingham, and is also a member of the directors, a member of the board of the directors of the Institute for Democracy and Economic Affairs Ideas. Would call upon and pass over to Christopher to take over from here to present his deliberations.
Oh, thank you very much, Stanley, for the rather extensive introduction. Thank you also very much to Arif for emceeing this. I had listened with much interest to the presentations by Tan Sri Abu Qasim, Dr. Punita, as well as Dato' Izani. And I think that overall, I'm quite encouraged by what has been presented, only because I think I have spoken on this topic a few times over the past few years. I'm not privy to any movements forward in the last few years. So it was refreshing and encouraging to hear from the three speakers previously on the various things that have been happening in the background. I mean, as far as the public is concerned, the Whistleblowers Act of 2010 has remained static in the sense that much of its provisions or salient provisions remain the same for the last 11 years since 2010. The other thing is obviously with the presentations by the speakers, that has made my job a little bit easier. They have covered much of the ground that I was intending to, but I think I'll just nevertheless share the slides that I have prepared. Let's see if I can do it. Stanley, can it be seen?
Yes, I can. I can see it, yeah.
So I'd just like to start off my session very quickly with a news report by Bernama earlier this month on the 4th of October, quoting the present MACC Chief Commissioner, Dato' Sri Azam Baki. And he said that, one, thus far, there have been 290 individuals who have been given protection by the MACC under the Whistleblowers Act 2010 since 2016. So between 2016 and 2020, 290 individuals. I know the statistics given this morning, or the data presented this morning, seem to at places be at odds. For example, the statistics from Dato' Punita shows that there was a sharp decline in whistleblower protection since 2016 till date. The information or the statistics given in the graph by Dato' Izani shows the other way, in the sense that it has been increasing since 2016. I prefer to be optimistic and therefore will go with Dato' Izani's figures. I think that is a healthy trend, that more whistleblowers given protection. And according to the MACC Chief Commissioner, 290 individuals since 2016 to date. However, he goes on to make certain very pertinent, important points in the news report. He says that in discharging its duties, namely the MACC, he said the MACC often faced problems in obtaining information because many people are still afraid to report on corruption activities. And so this is a recognition by our Chief Commissioner. Despite the statistics and the graphs and so forth, our MACC Chief Commissioner recognizes as of this month that it is still difficult to get people to come forward because people are generally still afraid to come forward. And he says among the factors that makes it difficult for some individuals to share information with their agencies is due to fear of being fired, or that by doing so, it will affect their business. That means retaliatory or detrimental action being taken. And that, I think, is also a recognition that members of the public do not yet have sufficient confidence in the manner in which their disclosure of corrupt practices would be managed in a strictly confidential way. And therefore, they foresee or have fear that there may be retaliatory action. And the Chief Commissioner goes on to say, we realized that to get individuals to come to us to lodge reports is very difficult. In another development, Azam said the MACC's aim is to build a Malaysian society with zero tolerance to corruption. So this is a statement by the MACC chief that recognizing these pitfalls, nevertheless, it is the aim of MACC to move forward, to try and plug these holes and see how reformation could be established. So to meet these aspirations, various strategies have to be formulated and would need the involvement of all quarters, including the various departments, agencies, he added. So I think that is a positive statement. MACC wish to engage, wish to reach out. And I think this particular platform, particularly with the participation of Dato' Izani from MACC, is testament to that. So I will move on with my slides with that short introduction. And let's see if I can do it. So what is a whistleblower in layman's terms? Really, I think all of us understand that to be, just any person who discloses information of a criminal offense or a criminal activity. It usually is with regards to corruption, whether in terms of monetary corruption, gratification, victimization, abuse of power, abuse of public office. And that disclosure is then made to the appropriate authorities. And I agree with Nades, who spoke just before me, that I think it should also include a disclosure to non-enforcement agencies. And later on, I will say why that is important. Currently, under the Whistleblowers Protection Act, a whistleblower will not enjoy the protection under the Act if a disclosure is to any other person, entity, organization, or body other than an enforcement agency. So examples of whistleblowers that we have had would be, of course, the Watergate scandal. And that was the whistleblower, I think at that time was a former deputy director of the FBI. And then in conjunction, and then he blew the whistle to reporters. And reporters like Nades then reported it in the news. And the lid came off that scandal. I think the other one at home was in the early days, I think it was in the early 80s, it was the Bmf Scandal. And that, again, was really, there was an internal officer from BMF sent to Hong Kong to do an investigative audit because they found certain elements in the accounts that did not jive. He was murdered. His body was cut up into pieces, stuffed into a suitcase, and left at a plantation. And when his body was discovered, then it was reported in the news, and then the ball started rolling. And of course, recently, we all know is 1MDB. And it was very important, that is a very important example because that is a clear example of what Nades Warren just said. The whistleblower was a guy called Javier Justo, but he got nowhere with whistleblowing. We all know that it was very challenging even within our own agencies to take action on this. In fact, it ultimately resulted with the removal, sacking, or in inverted commas, retirement of our former Attorney General, Tan Sri Abu Qasim as well. So the role that was played there by the media was very important. I believe two come to mind. One was The Edge. They came out with a series of investigative reporting that into 1MDB that threw some light into that dark corner. The other one, I think, was by a news blog called Sarawak Report, And that will tell you the importance, therefore, of recognizing these other avenues for whistle blowing. So we must remember what is the objective of the Whistleblower Protection Act. And in my mind, it is really one, to encourage a disclosure of improper conduct in the public and private sector, and importantly, to protect the whistleblowers. We must not lose sight of this objective because the technicalities of the Whistleblower Protection Act may sometimes not facilitate the achievement of these objectives. So one, I think, was in the earlier discussions talking about if a whistleblower goes and whistleblows to non-enforcement agencies, they do not enjoy protection. But I see no real reason why, in the context of the objectives of the Whistleblower Protection Act, such persons should not enjoy protection. Although if you follow the provisions of the Act itself, technically they would not enjoy protection. But if you adhere to the objectives of the Act, they should. Why? Because the Act is intended to protect two things. One, it is to protect the information. Two, it is to protect the person who gives the information. And if the person who gives the information decides to disclose that person's identity, there is no good reason to withdraw protection, because the protection is not just about the identity of the whistleblower. The protection is also the prevention of detrimental action to be taken against that whistleblower. So I give, for example, the case that was highlighted by Dato' Izani recently of a deputy director of the Higher Education Ministry owned company who has been charged under Section 10 for having taken detrimental action against a employee whistleblower. And the detrimental action in that instance was to terminate the employment of that whistleblower. And if you read the report, and I'm reading it from the New Straits Times report dated September 18, actually the identity of the deputy director is stated in the report. Now, if you look at the Whistleblower Protection Act, the confidential information includes the identity of the alleged wrongdoer. So what I'm saying is that even though the identity of the alleged wrongdoer is out in the public domain, and as well as the nature of the wrongdoing, that should not be a reason to retract protection for the whistleblower. So I just mentioned protection of confidential information, example, identity of the informant, as well as identity of the alleged wrongdoer. The Act provides immunity from civil criminal action. I do not see why such immunity cannot continue even though the identity of the whistleblower is known. What is important is that known or not known, that person ought to still enjoy this protection. Then there is the protection against retaliatory action, also known as detrimental action. So for example, termination from employment, disciplinary action, and so forth. Again, there's no good reason why such a person should not continue to enjoy such protection, even if that person's identity is made known. In fact, I would venture to say that it is even more important that these protections are in place when the identity of the whistleblower is known, rather than retract all protection once his identity is known. That whistleblower is then completely exposed, and that will not in any way encourage members of the public come forward in the future. So it goes on to say that anybody who takes detrimental action against a whistleblower contravenes the Act and will be liable, commits an offense, and will be liable to certain penalties. And this would be found in Section 10 of the Act. And then there are key provisions in the Whistleblower Act, and this is found in Section 6. This accords the protection itself. It says a person may make a disclosure of improper conduct. Improper conduct can consist of anything, as I said earlier, from a criminal offense corrupt practices, abuse of office, and so forth, that disclosure is to any enforcement agency. And this is important, as has been highlighted earlier during this webinar. You can only make that, currently you can only make a disclosure to an enforcement agency based on his reasonable belief that any person has engaged, is engaging, or is preparing to engage in improper conduct. And this proviso is important, and I'll come to it later because this calls for reform, provided that such disclosure is not specifically prohibited by any written law. So as a quick example, one written law is the BHEUU, the Banking and Financial Institutions Act, which prohibits disclosure of any information with regards to an account or account holder. I think we've all read with interest previous years of a certain disclosure by Rafizi, and Rafizi was then prosecuted for making a disclosure, which I think to a lot of members of the public, that disclosure was in the public interest, and yet Rafizi was prosecuted. The other thing is the enforcement agencies are really the police force, MACC, Royal Malaysian Customs Department, Immigration, and so forth. And then a whistleblower shall, upon receipt of the disclosure of improper conduct by an enforcement agency, be conferred with the protection. And then detrimental action, as I said, I've explained, so I'll skip that. And confidential information, I have already explained, and I'll skip that. So any person who makes or receives a disclosure of improper conduct or obtain confidential information in the course of investigation into such disclosure shall not disclose the confidential information or any part thereof. And I think this is a problem area which was highlighted by Tan Sri Abu Qasim, in the sense that now, because of the corporate liability for corrupt practices by virtue of Section 17, capital A of the MACC Act, companies are required or should have written protocols, guidelines to combat corruption. This will afford these companies a plausible defense to corporate liability for corrupt practices. And as part of that procedure, there should be a whistleblowing procedure within the company. But the problem, as highlighted by Tan Sri Abu Qasim, is that if an employee within that company or any organization does what is provided by that organization's own guidelines and protocols, namely to report a corrupt practice to the chief integrity officer set up and appointed by that organization, the chief integrity officer is not, in theory and technically pursuant to this Section 8, allowed to onward disclose that confidential information. So suddenly you have created a block and confined it to that person. And then there is the revocation of the whistleblower protection. It comes about in various circumstances, one of which is A, the whistleblower himself has participated in the improper conduct disclosed. And to my mind, that is a serious flaw, I think, in the Act. Because I think most of us know that very often the whistleblower is somebody within an organization or part of an initiative and may not be a participant, but has the information and knowledge and disclose. But at the same time, very often participants in the wrongdoing obviously have the information, and we would like participants, especially peripheral participants, to come forward and whistleblow. This provision will discourage any such person from blowing the whistle on their fellow wrongdoers. And I think that is counterproductive to the objective. You know, very often you may have people who are not active participants, but who are complicit. And I think these people should be considered for whistleblowing protection. It only provides more avenue for the enforcement officers to get information. So I come to a comparison. So that is my brief outline of the Whistleblowers Protection Act of Malaysia. Just a brief comparison, for example, with the UK. In the UK, disclosure is not confined to an enforcement agency. You can, in the UK, make your disclosure to a person of authority in whom the whistleblower has confidence in. It includes even your member of parliament and so forth. You see, when you make a disclosure, for example, to Nadiswaran, Nadiswaran as a reporter need not disclose the identity of his source. His source can remain anonymous. So in that way, that source or whistleblower can still, in theory, enjoy the protection of the Act, save for the provision which says you can only report or whistleblow to an enforcement agent. So that is why I think we should do away with that, allow whistleblowing to other entities other than enforcement agents. But, for example, if you whistleblow to a media, sometimes there is advantage to that in the sense that you run less risk of a cover-up the moment it is exposed by the media. And if the media keeps the identity of the whistleblower confidential, that whistleblower should still be afforded protection. In Australia, likewise, it's not limited to enforcement agents, so UK and Australia. In India, unfortunately, India confines reporting of corruption only to, with regards to corruption at the federal government level, so it's still quite restrictive. Ours is not so restricted. Our Whistleblowing Protection Act will cover whistleblowing with regards to any bodies, agencies, whether in federal or state level, public sector, as well as in the private sector. Well, I come now to my reforms. Actually, I've touched on it already in the course of presenting earlier. So most corrupt practices, serious criminal activity are not easily discernible or discoverable, highly dependent on information and reporting by insiders, namely whistleblowers. Now, there's a difference between an informant and a whistleblower. I noticed there was a question earlier. I'm not quite sure to whom that question was posed about Section 65 of the MACC Act, which affords protection for an informant. There is a slight difference between an informant and a whistleblower. Usually, an informant has a pre-existing relationship with the enforcement agency. So, for example, an informant of the police, they already have an ongoing relationship with the police officer, and that person is an informant of that particular police officer. And that is why the Section 65 talks about the actual complaint being lodged by the enforcement officer as opposed to the whistleblower. So the enforcement officer, in this instance, MACC officer, in receiving information from the informant and in keeping his informant's identity secret, because it will be a continuing relationship, it is the MACC officer that lodges the complaint. So on record, the complainant is the MACC officer. So that is really how Section 65 works. But I think that that can work hand in hand with the Whistleblower Act. I do not think that necessarily they are in contradiction to each other. So there is a natural reluctance to whistleblow unless there is confidence that there is proper framework and channel for disclosure. Whistleblower will be treated seriously and with respect. So on the first bullet point, that is pertinent to, I think, Dr. Punita's presentation, where in one of her slides, she had proposed that we could consider setting up a single body or agency for the purposes of dealing with whistleblowers, as opposed to varied and disparate channels or agencies. So, for example, if there's a whistleblower with regards to a customs issue, where does that person go? Corruption issue, where does that person go? Dr. Punita's, I think, proposal was to have a central agency so that members of the public doesn't have to go through this, oh, where do I go dilemma. You only have one agency that you can go to. And whistleblower, second bullet point, will be treated seriously and with respect. And this ties in with a comment earlier about whether or not a whistleblower would be informed as to the progress of action being taken or not taken. Because very often, if a whistleblower comes and whistleblows, and the whistleblower is kept in the dark, and currently under Section 13, and Dato' Izani mentioned Section 13, where the whistleblower is kept informed. But really, Section 13 only provides for information to be given to a whistleblower at the end of the investigation. Nothing is said, and sometimes the investigation can take years, and nothing in between is said. So the whistleblower is completely in the dark. The whistleblower whistleblows 2 years ago, and until today, the whistleblower does not know whether his information has been taken seriously, whether the action has been taken, at what stage the action is taken. And that darkness does not lend confidence to whistleblowers to come forward. Of course, they need to be assured that their information would be acted upon or taken seriously. The next would be they must enjoy protection. So what I said earlier, even if the identity of the whistleblower is made known for any reason, that person must still enjoy the protection. There is no good reason why that person should not enjoy the protection. I would suggest that it is even more so important for the person to enjoy the protections when their identities are known. And enforcement agencies has to be seen to be independent. I think that from our recent experience with MACC, I think that the MACC has been independent, particularly with regards to the 1MDB issue. I think we all must recall the detrimental action that was visited upon the MACC and its officers. Sorry, bear with me. I think my battery is just running low. That was visited upon MACC and its officers during the 1MDB. Tan Sri Abu Qasim, was kind of shunted aside. Certain MACC officers were being tailed. Certain MACC officers were being transferred out or harassed. So that is an example of an independent enforcement agency itself can come under detrimental action. What more an ordinary citizen? So it is very important to instill confidence and to have independent agencies. In fact, I'm going to spend the rest of my presentation on the independence of the agency. I don't think I would like to go in depth further because I think much has already been said. I'll just display the whistleblower slides. The rest of it actually is quite extensive. I'm amenable to C4 Center making my slides available to any of the participants. What I would like to talk about now really is that aspect of public confidence to be whistleblowers being dependent on confidence in the integrity, efficiency, resilience, independence of enforcement agencies. If those elements are not present, you can strengthen your Whistleblower Protection Act to the maximum. You will still find that it will not encourage whistleblowers to come forward because the agencies to whom they're going to make disclosures are not perceived as efficient, independent, with integrity and resilience. I would like to propose for your consideration, therefore, that since we are on the topic of Whistleblower Protection Act, and much has been said about corruption, bearing in mind our keynote speaker is Tan Sri Abu Qasim, that there be serious reforms looked into for MACC. And a few years ago, when Tan Sri Abu Qasim was still the Chief Commissioner, he had several engagements with civil society, including the Malaysian Bar, C4 Center, with Transparency International. In fact, I have with me, I know you can't see it, but it's 104 pages memorandum that was prepared jointly by the Malaysian Bar, by IDEAS, the Institute for Democracy and Economic Affairs, the Center to Combat Corruption, C4 Center, Citizens Network for a Better Malaysia, and Transparency International Malaysia. This memorandum was dated 28 July 2015. We worked, all these entities worked with Tan Sri Abu Qasim, who was then the Chief Commissioner, to look to making reforms to better MACC. I will just leave with you these several thoughts. One, at the moment, all of the personnel at MACC are actually comes under the PSC or the PSD, Public Services Commission, Public Services Department. So they are like any other civil servant, which means they are subject to the government, what do you call, standing orders, and therefore subject to like disciplinary action as any other civil servant. So an example has been given that even the Chief Commissioner himself may be transferred just by administrative action. So you therefore have a non-security of tenure of even the highest officer in MACC. And that makes MACC structurally susceptible to interference as well as pressure. So one proposal for your consideration is to embed MACC in the federal constitution, just like our Judicial and Legal Services Commission, our Armed Forces Commission, our Election Commission, that by setting up a body called, by whatever name, it can be the Anti-Corruption Services Commission, it can be the Independent Anti-Corruption Commission, by whatever name, set up under the Constitution. The composition of that commission should comprise of a combination of public sector officers and civil society personnel. I think there is precedent for that. An example of that is in the Republic of Korea. They have such a constitutional commission. You cannot remove the Chief Commissioner of MACC shall chair that commission. Currently, the Chief Commissioner of MACC is really a great turus dua officer, and therefore, as I said, subject to standing orders and disciplinary action, and liable to be transferred or removed. We need to give security of tenure to the Chief Commissioner. And in like manner as a judge, you can only remove a Chief Commissioner through a tribunalization process. But at the same time, you don't want to entrench a Chief Commissioner, so the tenure of a Chief Commissioner should be limited in the Constitution to perhaps two-year tenures or 2-3-year tenures, whatever that may be. The other thing is the recruitment of MACC officers. I think it's very important in this day and age as criminal offenses and corrupt practices become more sophisticated and complicated. You need specifically trained officers. Currently, recruitment for MACC officers come from the general pool of applicants. Applicants make application to the Public Service Department. They can indicate preference to join customs or police or MACC, whatever, but they're in a general pool. And then they are allocated by the PSC or PSD to the agencies. So the officers that MACC gets are not officers that MACC have recruited or interviewed or have in any way satisfied themselves would be suitable or have potential to be MACC officers. So I think the commission should undertake that process. I think I've taken too much time. Stanley, you have been very patient. I will end my presentation here. Thank you.
No, you're doing very well. Thank you. Thank you. Thank you for the thoughtful suggestions. And I think very much important points that have been made. And I agree with you on many of the points, especially where you have pointed out correctly that protection is not only about the identity of the whistleblower, but also about protection from detrimental actions. I think that is very important. But I just want to ask you one question before we go to the next panelist. One of the main reason disclosure is not allowed to be made to the public from the MACC's perspective is that due to the fact of the need for element of surprise when they are conducting the investigation. So when the matters are out there in the press and so on, then it's quite hard to conduct investigation. How do we address that then at that point?
Yes, I think that is not really a legal issue. It is a practical issue. I think from our experience, the key would be public confidence in the relevant enforcement agency. I think that if the public generally perceives confidence, as I said, in the integrity, efficiency, professionalism, and independence of a in particular enforcement agency, I think that they would like to take the reporting channel to that particular agency because they will then be confident that this is the safest, most confidential route. You know, it takes a lot for an ordinary member of the public to go public. And when you, let's say, go to Nadiswaran, you're actually going public. That means that person has already given up on any other channels, right? So I think the natural tendency of members of the public when whistleblowing is to actually go to an enforcement agent, but they need to have that comfort and confidence. Going public, I think, is to an ordinary member or layman is an unattractive alternative route.
Thank you, Christopher. I'll come back to you later on that. We have a few more questions on that. So now we'll be going into our final panelist for today, Mr. John Chung, who is from the multinational company background. In fact, for the information of everyone, many of our attendees today here, even on our Zoom and following us live on our Facebook, are from the MNCs in Penang, representing the Promise of Integrity Coalition, which is an alliance of companies set up to uphold standards of ethics and integrity within the business community here in Penang. We at C4 actually believe very much that the business community plays a very important role in the fight against corruption, and there's just so much to learn from each other on how to push forward this agenda. So we have John Chung here joining us from Singapore today, he's a regional compliance counsel at Intel based in Singapore, whose responsibility includes maintaining the company's effective compliance program. John is also a licensed attorney in the US, and Hearn is a Juris Doctor at New England Law in Boston with master degree in law at the National University of Singapore. His past experience in legal and compliance includes sectors in the shipping, maritime, and telecommunications. So on to you now, Mr. John.
Thank you, Stanley. And thank you, Mr. Christopher Leong, for the very insightful session. And to Mr. Nandeswaran and everybody on the panel. And thank you for having me on this forum to talk about a very important topic. First of all, I hope everyone is well. I know it's been a very challenging year and everybody is keeping safe and well during this pandemic era. So for my session, I would like to talk about and share with you really about our company's Intel's internal best practices compliance. What we do as a private company in Malaysia and also globally around the world. It's a very important topic for us. And as such, we have invested so much time and resource to build and really to give a concerted efforts to have a well-established and embedded world-class compliance program. And this is to ensure that our business operates not only legally, but ethically as well. So our basic stance is that business success is only possible when, as an integral part of the ecosystem, as mentioned before, that all of our stakeholders benefit both at an individual and societal level. And that kind of symbiosis between, the various segments of the society, the private company, the public, the individuals, and other key stakeholders is really critical to path to that success for us. It is consistent with our global mission, really, because we often say that our mission is to make every life better through technology, and this is where ethics and integrity becomes such a key role. So, through the years of efforts and in trying to implementing a compliance program, we were also privileged to be recognized by the Ethisphere as one of the world's most ethical companies. And the way that we do, and I'll go into our key topic, is really through our established and robust policies and procedures. So it's an organizational rule, it has to be absolutely clear. They have to be well communicated with clarity. And we have to, we conduct our periodic organizational risk assessments. This is through a proactive audits, proactive reviews, and also reactively speaking on investigations in the event when allegations or concerns are raised. All this is in our effort to continuously improve the robustness of the compliance program, and eventually those sort of risk assessment would be fed into our core policies, our processes, and our protocols as appropriate and necessary. So what's also interesting, I think, for us in the tech industry and going forward where the world is heading, is the deployment of cutting-edge technology that we have. And this is including in the areas of artificial intelligence, data analytics capability, and allowing us to further optimize our efforts in compliance and ethics wherever we operate. Now, of course, these efforts include, and one of the key components of all of this include an effective reporting program. It is a critical component. And I started off mentioning about policies, but that is so critical for us. So in effective reporting program, we have a very well-established policies that encourage people to report. And in certain instances, there is even an obligation to report for our employees. So the clear stance of where the company stands in terms of rule and reporting concerns is very straightforwardly laid out for all employees to understand. There is that continuous efforts as well in training and assuring our employees that these are what our rules are internally. Of course, the establishment of effective channels, and I think Mr. Christopher Leung has mentioned the importance of the channels, and I think that if I heard him correctly, a single source of channel to minimize any kind of confusion for reporting could be an effective one. Where here's an interesting fact: what we do internally at a company, and what we have done to establish this effective channels, is we actually have various sources of channel available, and we make it very known, not just internally, but also externally with our business stakeholders as well. So these channels include not only the ethics helpline, the ethics hotline, but also we have our internal legal and compliance councils. We have our human resources department. We advocate that they can go to their line managers to report any concerns. And of course, not all instances and not all the employees will feel comfortable speaking about an incident or a concern or even a question, seeking for guidance, speaking with the line managers. As such, we have another channel available, which is our internal, what we call the business champions. Now, business champions, in fact, are a little bit different from the other reporting channels, such as the legal and compliance councils, the HR, or the ethics hotline, in a sense that they are embedded within the organization locally, within the business. And what they effectively are is an advocate for compliance and ethics, and another channel where people can approach, where our employees can approach to seek guidance or ask questions. Now, of course, there's a sufficient amount of training provided in having this program run effectively, on the ground and globally as well. I mentioned about the importance of first having a very clear rule of where we stand with reporting and the channels. It's all part of the policies that we have at the company. But important is also our continuous effort in communicating these policies and procedures and reporting line. It's good that you have this out there, but what good is it if not many people know about them? And so there is that continuous and concerted effort to ensure that our policies, our procedures, and these channels are communicated throughout the entire segment of the organization. And you'll often hear, and we often talk about, our leadership or our top managers on site globally, and also at the mid-manager level, to cascade this message down throughout the entire organization. It doesn't stop at one show. It doesn't stop at one instance. It is a continuous thing because we have new employees coming, people are changing, and sometimes reminder is really important. And it's been done over the years where now there's a solid understanding of what the policies are and what the reporting channels are. But like I said, it is a continuous endeavor. It never ends. The part of the reporting process I think we want to talk about is for companies, for private companies, and talking about best practices, helpline and reporting process. Once we have it out there and we provide sufficient assurance through various levels of the company, an assurance that the process works. There is some level of marketing involved. This is out there. This is for you to utilize as appropriate, responsibly, and there are support. We advocate strongly that non-retaliation is strictly prohibited, that we have a very strict zero tolerance policy for any retaliation for raising concerns or raising questions. And with this kind of assurance, you have to act on it. So there are a couple of things in the reporting and processing perspective that is important for us. It is in the judicious response and speedy resolution. An investigation cannot drag on for a long time. It loses, it loses the momentum. It loses the effectiveness, and through times the information can also get diluted. So it's critically important that, especially pertaining to high-profile cases, that these are heard very loud and clear by us, acknowledged that these are heard, and that we act judiciously in responding to them in our review. And of course, there's the review itself. We review the matter, we review the issue. We contact the reporter, we contact the various identify the various stakeholders that are involved. And along the way, and I think as what we currently do from a national perspective is to inform the reporter and keep the person informed. That's exactly what we do. And as a matter of resolution, at a very high level, information is shared that the case has been reviewed and closed without going into detail for confidence. Certain instances, confidential matter. Inevitably, it's not only finding, what policies have been breached in the allegation, and finding whether that policy or in certain instances regulation have been breached, but also it's critical for private companies such as ours, where we have presence everywhere, is to really go a level deeper to understand what the root cause is. So the root cause analysis is a critical component of our, so to say, concern raising or helpline reporting process. This is really to understand not only on the fact-finding part that certain policies have been breached, but to understand the underlying reason, the gaps, what have caused this kind of incidents to have occurred in the first place, so that we can take proactive remediation to further mitigate going forward of this similar incidents from arising. So that's the kind of the review process and the depth that we go. I talked about clarity on the policies. I talked about the importance of communicating effectively at an organization such as ours. It gets communicated to everyone, and because everybody's a stakeholder, and the importance of judicious response and deep dive root cause analysis. Of course, the reporter have an option, as we all do, to report the matter candidly, openly, as we often experience, because a lot of our employees have that level of confidence that retaliation will not take place. But the channel is available, that in the event an employee wants to report things anonymously, that is also kept very, matter is kept very confidential and in secret, and assurance. Further assurance is provided, that any harm will not come the reporter's way. And this has worked for many organizations. I think if you speak with many multinational companies who have exposure to relevant regulations, and also who are also on the boat of acknowledging the importance of that ecosystem, the symbiosis, and how ethics and compliance play a very important role in that ecosystem to add value. You'll pretty much hear the similar sort of story of how companies embed an effective compliance program by going further at the core, and the very importance of it is to embed a very effective internal reporting channel. At the end, what we do is periodically, annually, if not more frequently, we go through a pulse survey. We go through various surveys to assess where we are engaging our employees' confidence in going to that reporting channel, in utilizing those available channels. And the kind of questions that we ask is, where are we? How do you feel comfortable using these helplines? Do you fear any kind of retaliation for asking questions? And these give us a pretty good indicator of where we are on geographically throughout the organization, and what we have to do to further assure that the confidence is kept at a very high level. It's never enough for us. For us, 98% confidence is not even enough. It has to be 100%. So that's what the target is. And it does require a considerable amount of effort and collaboration, cross-function, and a very strong leadership. I'm sharing the compliance best practices because I thought it would be helpful and beneficial to understand what we are discussing here, which is an effective whistleblower line. That is a very important topic, and I hope what we do, what we have shared with you, contributes to that dialogue in reaching the best outcome. Thank you.
Thanks, John. Yeah, I think there's just so much that we could learn from the private sector. And I think the point about communication or communicating effectively, the whistleblower policy in your company is something that I think the government should look into seriously about. Because I do believe that there are many departments, even government departments themselves, who are actually not well aware of the whistleblower policy in our country. They do not know what what the act covers, or how they could make a complaint, and they're not confident enough about the act. So I think that part could be a great learn for the government in terms of communicating effectively to everyone about our whistleblower policy. Before I go further to ask you another question, I just want to remind all our participants who are following us right now, if you have any questions, please put in your questions into the question box, and I will direct it to our panelists who are here with us right now. Yeah, John, I just wanted to ask you. Recently, the European Union adopted a regulation for whistleblower protection. I think it was in December last year. The regulation directs member states to draft laws in regards to, whistleblowing and wrongdoings related to money laundering, tax evasion, procurement offences in the company, and so on. Now, the one of the good thing about the recommendations is that the whistleblower can actually choose whether to report a concern internally within the company or directly to the government authority. And the regulation details out what actually the company should do, how they should treat the complaint, and if nothing happens in response to the complaint that has been made, the regulation also provides where the whistleblower can actually go out and make the information public and still be protected under the Act. My question to you is, do you think that Malaysia actually needs a specific sections in the Whistleblower Act detailing out how companies should actually, cover or should have mechanisms in place to deal with whistleblower, with whistleblowers in their company? Do we need such laws to actually govern how companies should actually have the structures and so on? I mean, we know we have section 17A in the MSCC Act, a general section, but that is merely a guidelines. I think the guidelines are up in the Prime Minister's Department document. You can find guidelines on how whistleblower, what the company can do in order to have a conducive environment to address corruption issues and so on. But do we need a specific legislation? Would it be helpful for companies in that sense?
Well, I think a lot of companies, are moving in the direction, not just because of the regulatory environment, but realization that kind of stakeholder and symbiotic relationship is very important. And so, like I mentioned, ethics and compliance and a reporting channel is a critical component of that. As to having a specific law, it's difficult, but what we currently do have in Malaysia is similar to what we have in the UK Bribery Act, is for companies, for failure of having an effective compliance program can implicate the company. And that, as Mr. Christopher Leon has alluded to, received quite a lot of attention and focus by companies to have a robust compliance program. I do not see how a compliance program can be effective without an effective reporting line. So by effect, by the current regulation environment we have, we already encourage companies to adopt an effective reporting line. It's a question whether we need anything further than that.
Okay, thank you, John. Let me just check my question box here. I think we have a comment. Just let me read out a comment. Act 605 also prevents academic from whistleblowing on their own organization. Lots of abuse going on in local universities. Any comment on that? Christopher, probably, or Nadis, secondly?
Yeah, thank you very much, Stanley. I think, yes, it's a problematic area. It was touched on, I believe, by Dr. Punita earlier, and I recall her saying that they are going to look at it because there appears to be inherent in the Whistleblower Protection Act a contradiction. Namely, the Whistleblower Protection Act objective is to encourage whistleblowing, and in doing so to provide protection. But I think it's Section 6, which provides that the disclosure cannot be with regard to information that is protected by law. So I gave the earlier example of BHEUU, and I think your comment just now by a question from a participant, that is with regards to the education sector. So if there are legal provisions imposing a duty of confidentiality on members or employees of that particular institution or sector, then it is on the face of it outside the protection of the Whistleblowers Act. And I think that's what Dr. Punita mentioned earlier, that they need to look into that internal contradiction. I think I would just like to make a quick comment also with regard to your earlier question. I think a lot of people do not realize that apart from Section 17, capital A of the MACC Act, which provides for corporate liability for corrupt practices, that is actually there to encourage corporations to take measures to fight corruption. There is a counterpart to that really that has always been there, even before Section 17, capital A, and that's in our, I think, our penal code. I can't recall what the section is. There's actually an active duty imposed on everybody to report serious offenses. It is an offense not to report a serious offense if one knows about it. So that is the counter obligation of everybody else. So you need an organization to set up proper reporting whistleblowing channels to protect the whistleblower. And at the same time, the penal code imposes an obligation on everybody to report commission of serious offense.
Thanks, Christopher. Any, you want to add on anything on that, Naresh?
Yes. I've dealt with a couple of complaints from academicians in universities. I've written about it without naming the university for obvious reasons, where lecturers, when asked to pass all students and everything else. In fact, the heading of the story that I wrote was, no one fails in this university, right? So it happens. And the reason is because of their own internal regulations. No one is allowed to speak to the press or to release any information. So it comes to me, and I got to publish it. The second one is even worse, about non-academic staff in the university asked to go and register themselves with the Malaysian Qualification Academy, GIACC, right? So you're not even lecturer, but if you're there as a personal manager, just to make up the numbers, using your qualifications, you go and register. So that is only one aspect of the education part of it. There are several other organizations where even speaking to the media is taboo, and people have got into trouble for speaking to the media on issues, let alone going to MACC or whistleblowing. So that is why I'm saying there should be a protection for all informants. You see, the MACC system is wrong. You go and register yourself as an informer, right? Or you register for protection, but that should not be the case. As I pointed out earlier, the policeman does not know anything about registering. Who in the immigration department do I go to? And I know I'm complaining about corrupt immigration officers. How do I go to the department and complain? Now, these are things we should look at when there's any amendment, right? The two from the MACC pointed out, they should come to us. Have you ever come across an informant where I've not come across, always an informant have gone there, right? But this is it. They want public support, but they don't come out and say these things. Give us a call, we'll come and get you, or come to you. So this whole thing about protection, I'm really not really happy with the existing system. Now, Balbir Singh, Jesse, my former colleague in the NST, now he's a chief integrity officer in Johor, has made a suggestion to something on the lines that there should be mandatory jail sentence. But again, I think Chris won't agree with that, because if you put mandatory, then you're tying the hands of the judges, right? But he has said that only the deterrent is first the proposed mandatory jail sentence against any employer who takes against a whistleblower, right? As I earlier asked the MACC guy, why did Dogma have to go to take civil action? They should have called him in the protection, right? And they did not do anything. They got one case so far, and they're bragging about it. Even in that one case, they exposed the name of the whistleblower. Where do you go from here? I hope the MACC guys are still here to answer these questions. But this is it. You want public to give you support. You want people to come forward, and you do these kind of things. Who in his right mind will go in MACC, knowing that when it comes to prosecution, your name will be mentioned as a whistleblower? How can it be? So there must be a mechanism, right? Maybe the press is the ideal conduit. A lot of people come to the media, and we take it at that time when Abu Qasim was the chief and Shukri Abdul was his deputy. I think we worked so closely with each other. Every tip of we got, we passed it on to them before we even wrote the story, right? This is happening, this is the information we got. These are the documents we acquired, and we pass it on to them, right? That gives assurance to my informer that nothing is going, your name is not going to appear anywhere else, right? Anything else, I'm putting my name to the story. But
in regards to breaking the story to the press, do you think there should be a specific time frame, where, for example, let's say if the investigation there was no response or there's no update, let's say in 3 months since the report has been made, and then the press should be allowed to actually expose those issues and so on. Do you think that sort of time frame should be stated?
No, I'm talking specifically about reports, documents, and everything else. What is happening now is the press is going to cover every press conference outside the MACC building. The guy who makes a police report or makes an MACC report, he's standing up and holding the report, right? Come on, he said, you don't have any evidence, you're just going on hearsay, right? Come on. You can't, if you come to me, I chase you away because I say, well, what evidence have you got? Right? For me to run a story, I must have the documents or evidence or whatever it is. You come and say so and so is corrupt, okay? It's a good help. Like the example I showed you just now, on the appointments made in the tourism ministry, the informer came to me with all the documents, the appointment letters, right? So when I passed this whole thing on later, but then again, it's all administrative stuff. At the time, the Prime Minister was not so keen in putting up his ministers, so it just went away. But this thing is still happening today. Right? I raised this earlier in the morning. The Prime Minister offering a bribe to his MPs in the form of positions in GLCs. What more evidence do you need than this? This is an admission. The recorded voice message has gone viral. Everybody knows the Prime Minister made an offer to MPs of various parties to join the coalition and give them a post which gives them big 6-figure incomes. What has the MACC done about it?
Yeah. Okay, I just want to address one more question that just came in right now. do the panelists have an opinion on possible abuse of powers within the ranks of MACC or its advisory panel in terms of whistleblowing? Anybody want to take that?
I don't think there's an issue of that. I think let's credit the MACC officers.
Yeah.
With most of them highest standard of integrity. I worked with them several years, but there are one or two black sheep which were now been to court, and two of them have been charged. Yes, but this is why I'm saying you must give these officers some kind of support. If you remember, at the height of the BMF 1MDB investigations, one of them was transferred to the PM's department. Two of them were suspended just because they received. Now that is where you needed support. A man like Shukri Abdul, who was then the deputy, came back and went and told the chief secretary of the government, if they are not transferred within 24 hours, I'm going to charge you for obstructing a public servant. You must have that kind of leadership within the organization to do that. But all that has changed since, right? What we heard, Tan Sri Abu Qasim can confirm this. His successor took the entire team, entire investigating team, the 1MDB case or SRC case, to menghadap a lady in precinct 16. Why should a team of investigators go and present themselves to this lady? But this was done. So if you tell me now whether we've asked this question about integrity among MACC officers, sometimes they just follow directives, right?
Yep.
Otherwise, I think the team that was working with the SRC, I met them. I can tell you, they're a bunch of wonderful guys who worked on things. They've got the conviction now. If they'd been any way crooked, right? So much evidence could have been disappeared. They wouldn't have got Dato' Subo back as a witness, etc., etc. So
okay, I'll come back to you. I'll come back to you shortly, Nadis. I just want to address one question right now. Probably to Christopher. What is from Zaiham Ahmad? He states that what is our readiness to consider extension disclosure to other than enforcement agencies per Australia, India, in particular in regards to protection to whistleblowers? What would be the drive to go this route vis-a-vis states shared by the stats shared by Dato' Izani? I think you did mention just now about this, but yeah, maybe just to elaborate further about this.
I think that well, unknown to me until this morning when I heard Dr. Punita's presentation as well as Dato' Izani, that there is concerted efforts in the background to relook at the entire act with a view to seeing if it could be improved or made more robust. And one of the points that have been raised was this particular question, that a whistleblower should have the ability to also make disclosure to a non-enforcement agency. So I think that there is definitely initiative to look at this aspect. I do not know whether or not that will eventuate in any amendments. I will certainly, for one, will take the opportunity to advance the argument to encourage them to, in fact, do so, to allow the alternative. We're not saying that a whistleblower has to take that route. This is just an additional route or channel that is available, just like as John mentioned, even within his organization, and that's one organization, there are several channels in which a person could make a disclosure, and that choice for the disclosure really is up to the person at the particular point in time as to how confident they are in any particular channel.
Okay. John, what's the statistics like in terms of whistleblowing in Intel? Do you have many people coming?
Oh, well, it's keeping our compliance and legal folks busy, but you know, there's it's quite when we look at the stats, it's quite different. And that's primarily due to the pandemic and work from home and the whole change of the environment. So there's certainly somewhat of an anomaly of the cases that come through. But the reporters, they come from various channels. We do receive reports from the helpline, and it's there's always going to be a room for improvement, and we're going to continue to push that to make sure that people understand that these channels are there, and advocate advocate people to speak up, essentially. But what we're seeing right now is an effective channel, and these are somewhat of an encouraging stats. On the other hand, I think this is a unique era, so we are seeing some anomalies in our stats.
Yep. Christopher, I want to come back to you. In regards to accomplice, when you were saying just now, and even I was reading your ideas policy paper that you written a few years back. You specifically mentioned that to amend section 11(1)(a) to ensure that the whistleblower will be protected even if he or she was a participant in the improper conduct, as long as he or she is not the mastermind of the whole act. I just want some clarification here. Does this discretion is not with the AG? I mean, the AG can decide who to charge and who to be made a witness. And if that particular whistleblower is made a witness, then does not the Witness Protection Act comes in here to protect that particular person? Do we need actually a specific law within the whistleblower protection?
Yeah. So I think that the quick answer to your question is yes. But there are many situations or nuances in real life. So very often, the public prosecutor does have a discretion whether to charge or not to charge a person. And that very often comes about when the public prosecutor forms the opinion that there's been a commission of a criminal offense for which a valid criminal offense, a charge could be levied. And then there could be plea bargaining. In exchange for your cooperation and turning state evidence, we will agree not to prosecute you. And very often, that decision is made by the public prosecutor taking several things into account, one of which is the level of that person's culpability or involvement. So obviously, if the person was one of the prime movers of it, that will weigh into that decision, or if the person was just a supporting actor. But that doesn't address the situation where there is a person with information out there who wants to whistleblow for whatever reason, and not necessarily within the eye view of the public prosecutor in terms of prosecution. So that's what the Whistleblower Act provides. In fact, there's another legislation that can work hand in hand with whistleblower provision, as well as Section 67 of MACC, and that is a Witness Protection Act.
Yeah.
2009 or something like that. But that really is very often used with regard to a witness. That means there is already going to be or already has an ongoing case and a particular witness, and that's why they call it a witness. That person is going to give evidence. Whereas if you look at the Whistleblower Protection Act, there's a provision that talks about non-disclosure of the confidential information in court proceedings. I think you will recall Dr. Punita already mentioned that was another internal conflict that they need to look at and sort out. So the Witness Protection Act covers witnesses who are going to give evidence. Whistleblower Protection Act thus far only covers people voluntarily, not as part of a plea bargain, voluntarily giving, disclosing information. And that information currently is not to be disclosed even in court proceedings. So there needs to be a little bit of a reconciliation between the two acts. Then they can act smoothly hand in hand together.
Mm-hmm. Thank you, Mr. Christopher. So any more questions from the panelists? We are actually about to end. just on time. Anyone else who would like to ask any questions? Probably. Anyone from the panelists who might still be around? Okay, I think any panelists want to say any
Yes,
other few words?
I just one suggest.
Yep.
All the suggested amendments are good in paper and everything else. The bottom line is whether they have the political will and determination to make it happen. Okay, I can personally tell you the story about the MACC Act. Before it was an act, it was a bill. I'll take an oath of secrecy to go through it before it's tabled in Parliament. I was so happy there was a clause which said it shall be an offence for any person to have assets or lead a lifestyle not proportionate to their declared income. This was the best. If you had bought a house for 4 million, I wouldn't know where your money came from. The bill was supposed to be tabled in Parliament on Monday. It was delayed. On Thursday, that clause was taken out of the bill. So again, here we talk about all the proposed changes and everything else, and it goes up to the powers that be. Will they agree to all these changes? That's the biggest worry when it comes to discussion like that when you submit proposals. It's very worrying because it happened several times before. You send something good and it's shot down without any apparent reason. Thank you very much.
Thank you, Naresh, with that. Yeah, Christopher.
Yeah, thanks, Stanley. I just want to end very quickly by first, of course, thanking you for moderating this session. To my fellow panelists, John and Nadeswaran, thank you for your input, information that I will now write down further. And of course, to the organizers, I think it's very important that this topic continues to be out there in the public domain so that at least there's a continuous impetus towards looking at reforms. But I would like the reforms not to be too micro or tunnel vision. As I said earlier, I think when we're looking at reforms in this area, we should zoom out and look at the bigger landscape. So we should look at not only of course, we should look at amendments to the Whistleblower Act. We should look at strengthening MACC as an institution by amending the federal constitution. We should also look at bifurcating the role of the Attorney General and the public prosecutor. Therefore, prosecutions only come under the public prosecutor. We should also look at Freedom of Information Act. I think if you look at other jurisdictions where they have that act, access to information has been one of the factors for uncovering corrupt practices. So I think we need to look at the landscape holistically. Thank you very much.
Thank you so much, Christopher, for the insights. John,
I would just like to thank everyone for a great panel discussion on a very important topic. And as Christopher and everyone here would agree, is a type of discussion that we want to have ongoing openly. And that's how we make an advancement. Thank you for having us.
Thank you. Thank you, Christopher, John, and Nades for joining us. Thank you to all our participants as well, who actually this is just one of the first series that we are organizing. We're actually planning to have a second discussion, and this will be in Seremban. But now due to the COVID thing, so we are quite prevented from that. So we probably hope that once the COVID thing subsidized, we're going to go to Seremban and particularly engage with the civil servants there in Seremban, because I think they also have important to be engaged with. In fact, this particular session right now also, we were supposed to organize it in Penang with the involvement of the civil servants from the state government and local council. But we cannot have it physically. So some of them from the local council are actually joining us right now live here on our Zoom application as well. So definitely we will be taking this further. Yeah, you want to say something?
Yeah, sorry, I forgot to also thank all of the participants who following this webinar.
Thank you.
Yeah. So we'll definitely be taking this further with the other sessions and so on. So thank you once again to everyone, to the panelists and to all participants for joining us here once again. We will get the slides. Some of you have put into the comment that you all want the slides of the presenters. Yeah, definitely we will put the slides out to you all in our Facebook page or via email. We will get in contact with you all shortly in the coming days and so. So thank you once again, and we'll see you all. I'll go back to pass back to Arif. Arif, before Cynthia says the final closing words. Yep.
Hi, sorry. Yes, thank you, Stanley, for passing back the floor. Of course, thank you, Mr. Leong, Mr. Chung, and Mr. Naiswaran for the insightful panel discussion. I'd like to now pass the floor to Ms. Cynthia for the closing statements.
Hello, everyone. This is Cynthia again. I just wanted to say, first and foremost, that it's going to be really quite impossible to capture everything that was said this morning. It was such a rich discussion. And we were telling ourselves earlier that it was going to be that because everyone came with a very specific expertise. We listened to the government in the morning. And I just wanted to echo some of the things that Chris had said, sort of in closing. One is how important whistleblower protection is and what a central pillar it is in the whole fight and the whole battle against combating corruption. We listed a whole range of challenges, but there are some interesting things going on in the background, and we never knew it was going to happen until we heard Tan Sri Abu Qasim and Dr. Punita actually telling us some of the efforts that were going on. So there's a lot of things that need to be done still, despite the political uncertainty before us. There's things like developing the organizational anti-corruption plan, state-level engagement, beefing up a reward system. But most of all, what Chris talked about, which is the overall, I mean, this was something I worked with him on as well, which was the independence of the MACC, which was the big picture, the landscape picture of looking at acts that actually prevent the enabling environment, such as the Official Secrets Act, Section 203 of the Penal Code, and many implementation issues that were also raised by Dr. Punita. For example, court cases. Does that mean that all the information will then be divulged in court, and what happens? So perhaps one thing that I was hoping would be discussed and maybe should be kept for the next series was the issue of international cooperation. We find that many people take outside channels to blow the whistle for fear of reprisals here, or they actually work with law enforcement in different countries when the corruption scandal gets obviously cross-border. So how does that work in terms of filing a case in a different jurisdiction, or in the case of the DOJ and the 1MDB, or even multinationals like Intel, you have your presence in so many countries. How does it operate in terms of international cooperation, and whether that would be something for whistleblowing practices to be emulated through law enforcement agencies? I also wanted to state now how important it is for the private sector to share best practice. I think we learned a lot from the Intel experience, from what John had said, that there could be many things that local GLCs should be able to take on and emulate. But here we find that government-linked companies become one of the major sources of corruption as well. If Nades, for example, wanted to write a story, he'd be depending on inside scoops. And I'm not talking about the ice cream. I'm talking about really insider information coming out. And so this is another area that I think we need to elaborate and work on. So in all and everything that's said, we wanted to say that we're just starting off with a series of 3, but we are very open to actually work with all of you experts and to tap on your expertise in the future forums and to actually get things a bit more grounded, like doing things at state level, at local government level, where we know the issue of corruption can be very rife, and what kind of whistleblower protection mechanisms can be set up at local government, state government level, and how the Whistleblower Protection Act actually applies in this context. So there's a lot more room for conversations and engagement. And I wanted to tell you in advance that because of the COVID third wave, we had to postpone the other 2 events to next year. So we'll definitely be keeping in touch with all of you. We learned so much, I'm sure you did. And I was particularly very impressed with the questions that were asked by the participants. These were very experienced, real-time questions coming from real experiences, some frustrating, some actually quite thought-provoking. So I believe we have a lot before us. So it isn't just GIACC and C4 that should be working on this, but I hope we'll all be able to enter into greater partnerships from here on. Thank you very much.
Thank you.
Thank you, Cynthia. So before we end, I'd like to once again thank all of our speakers for their contributions and also to all of our participants for attending today and being part of the event. Thank you also to the National Center for Governance, Integrity and Anti-Corruption for their cooperation in putting together today's event. As mentioned earlier, today's public consultation is the first in a 3-part series that we hope to conduct in the future should circumstances permit. So in that sense, do follow C4 Center and GIACC on Facebook for updates for those events. And also one more thing, as mentioned earlier, the recording of this event can be found on C4 Center's Facebook page. After this, in the coming days, should you wish to revisit any points from our discussion. So with that, thank you all once again and have a great day ahead.
Fantastic. Good job.